This.
Sir, it's number 3. You should go to number 1.
Yeah. I don't know where. Yes.
So they said it is regulated.
Yes, Mr.
May I, Lord, if your lordships can, my lord, may I request your lordships to come to page 3 of this?
Please use the mic.
My lord, just in this. I'm sorry, my apologies. Page 3 of the note.
Yes.
We have categorized, my lord, all the matters in 3 categories. Category 1 is, my lord, concerning section 6A of the Citizenship Act. Lord, that is kind of a parent question, my lord, which if decided, your lordship may not have to right now go into category 2 and 3. Category 2 is NRC issue. Well, someone has challenged NRC validity, etc., the procedure, rules. Some of them challenge, my lord, validity of the rules. But again, dependent upon what my lords decide on the first category. And third is, my lord, foreigners tribunal.
Right.
So that these are, my lord, SLPs against the orders, etc. That is completely a different issue. Sometimes, my lord, we request that tag it, and that's how, my lord, it seems to have been tagged. We means not the government, on our side, the bar. So, my lord, if your lordship can consider taking up category 1, subject to, my lord, lord hearing other side, then, my lord, rest can be staggered and can be decided later. Otherwise, it will become very, very confusing.
This category also.
Well, it's what we've done for your, I'm sorry.
In the category 1,
Well, that's what we've done for your lordships is that sent to your lordships a compilation of all the issues, all the questions of law that have been framed by each council. That's in a compilation. I can give a hard copy, but it's also been sent to your lordship.
Look, that is page 1 of my.
It's already there. There. That's yes.
Yes,
But that's his
page
note.
1.
Other council have framed other issues.
Mr. Sybil, if you
All that is.
one.
It's all right. So we have first the draft issues as approved by the Attorney General
Yes.
and charts segregating the matters, then suggestions of Mr. Kapil Sibal, Senior Learned Senior
Yes,
Counsel.
yes,
Then comments on the draft issues by Mr. Dushyant Dave, Senior
yes,
Counsel.
yes.
Then we have one from Mr. Manish Goswami, Mr. Ankit Yadav, and Mr. Somiran Sharma.
Correct. Melissa, what your lordships can do is, Melissa, formulate in the context of all the various issues, what the issues should be, Melissa, and then we'll argue, Melissa, on that basis.
That's
what I
might
suggest.
decide.
Because on the
What we were
categorization,
suggesting
we
was
have no
that
problems, Melissa.
since all of you have now given your suggestions,
Yeah.
why don't you all sit down together for 15 minutes and give us the agreed issues on the basis of this?
Well, that-
For instance, item number, Mr. Sibal has said, with regard to issue number 3 relating to Article 14, it is suggested that the issue same may be removed in view of issue number 1.
Correct,
Really
because the
dealing with
first-
article.
That's correct. I agree to that. It's encompassing the first issue.
Actually, this categorization.
Put section 6A.
Yes, categorization.
All challenges to section 6A will be under one head according.
Correct, correct.
So those are all the grounds on which we are challenged. Whether 14
That's correct.
Whether 6A is valid or not, Melissa, that's the only issue.
One issue that we had tracked, my lord, appearing for the All Assam Students Union, which was a signatory to the historic Assam Accord, which brought in 6A for restoration of normalcy. My lord, we had made a suggestion based on the reference order of 17 December 2014 that the primary issue should be that whether 6A constitutional validity should be actually, my lord, gone into at least, and what would be the repercussions and consequences, which is a question that has been formulated by the learned AG. We are only requesting for it to be treated as a preliminary issue.
We'll consider it after.
no, this is not the only issue. There are other issues, my lord.
That's all right.
Yes.
That's my
They are
suggestion.
trying to express their perspective.
Let the issue of the
Perspective is not
constitutional
the end of the
validity
world.
of 6A be decided upfront.
Yes.
Once your lordships decide that, then the other matters can be taken up, depending on how your lordships
Another
decide.
issue, my lord, would be, would your lordships, my lord, in a writ jurisdiction go into the question, which is the subject matter of something which happened, my lord, before 40 years. So the question of delay is also one of the essential.
That's a matter of submission.
Possibly.
Really.
Correct,
That's a
correct.
matter of submission.
My lord,
We'll
that
do of
that
course,
aspect has already been gone into by the reference judgment, my lord.
regarding delay in approaching, that aspect has already been taken care of. Only thing is, in view of some right which is being enjoyed by this category of people, when it comes to molding of relief, what could be the approach? That is perhaps what was
now is
indicated
this.
in the reference judgment.
We have draft issues.
One second, my lord, let my lord the Chief Justice.
We have the draft issues before us, which have been prepared by the learned AG. So the first issue there is the validity of section 6A.
That's right.
So we will decide the issue of 6A
First,
front.
correct.
So that we can say that initially we'll frame the following issue for submissions, namely whether section 6A of the Citizenship Act 1955, which says it violates articles 14, 21 and 29(1) and offends 5 to 10, 11, 325, 326 and 355. The first two issues I think are
Correct. Anything else will arise after that. Let's first decide that, then your lordships can decide what to do thereafter.
Two also, my lord, can be merged. Some additional articles are mentioned.
It can be a common also.
So what we can say is whether 6A of the Citizenship Act 1955 is ultra vires, we can say, or suffers from any constitutional infirmity.
That's
Yes.
That's correct.
Right?
That's
So we'll
correct.
say that.
Another.
And then second, so that covers 1 and 2.
Yes,
3 is also subsumed.
yes.
Now 4 is the statutory ultra vires. It says whether 6A violates the fundamental basis of 5(1) proviso and 5(2) of the Citizenship Act. So do we?
4 doesn't really come into the picture because it talks of East Pakistan, Mullah, and it talks about Bangladesh. Those reciprocity, that's fully irrelevant. There was no question of reciprocity either from Bangladesh.
So what presently we will do is, we will frame.
So this should be dropped, Mullah. This should be dropped.
My lord,
Presently, let me just say 1 second. Presently, the following issue is framed for primary determination before the Constitution Bench, whether section 6A of the Citizenship Act 1955 suffers from any constitutional infirmity.
That's fine.
That covers.
Perfect.
that will be all comprehensive.
Or violates any statutory, because issue number 4.
All those.
My lord, issue number 4 is the very relevant, my lord. With great respect, I'll submit. Because when we
So
go,
what we'll do is, we have framed that primarily as the issue which we are going to discuss.
Broad issues, my lord.
This does not prevent us, once we start opening the
Correct.
matter, we'll frame something more.
Correct.
Would your
It's
lord
not like a civil suit that, then.
our lordship may keep one residuary issue, my lord, where we can all bring.
Lord, would your lordship see issue 9, my lord?
9,
Kind consideration, my lord? 8 and 9, my lord. 8 would be, my lord, part of an argument, but still kindly see whether the Assam Accord, a memorandum of settlement between Union of India, the state of Assam, all Assam student unions, and all Assam Gana Sangram Parishad arrive at for resolving a long pending issue, being a political settlement and a matter of great policy importance, can at all be judicially reviewed at this stage, as courts will decline to enter into political thicket and annual matters of such magnitude and with immense consequences.
But that's an argument in support of upholding 6A. Mullah.
I agree.
This was
Nine,
an argument, it can't be an issue, my lord.
Can't be an issue.
9, only a minute. 9, whether delay is a factor that can be taken into account in fashioning reliefs in a petition filed under 30.
therefore, Mr. Solicitor, we take it that your submission is that 6A is valid.
Yes.
Additionally, of course, it's not constitutionally ultra vires, but it is valid also for the reason that when the government has enacted a statute to give effect to an accord and consistent with the delay, therefore this provision should be upheld. That's your
That's correct.
So this is really an additional argument in support of your submission that 6A is valid. So we can argue that when
Because union has been supporting Mullah, the 6.
Yes, my lord, we are not.
For 9 also.
Supporting.
Same way.
Likewise for 9 also, Mr. Solicitor, your 9 is subsumed. So we will not stop you from arguing that. You can certainly argue that.
Please, sir.
It is in the form of
Submission.
Respect, which was framed by the reference judgment issue number 12. If your lordships would kindly have that as very important, my lord.
What is that?
My lord, reference judgment, my lord. My lord, it's 2015 3 SCC page 1.
वो दे दो जरा.
Yes. can I make one submission? Lord?
Yeah,
The
let's
issues
just, he's just getting. For 2015 nahi hai. No problem.
2015, yes.
3 SCC page 1.
I've told him now.
Indicated in page 26 of the report.
Just one second. Let my learned brothers.
Well, para 30 is matter 26. Just to give an idea, my lord, what were the original issues?
This issue.
Whether Article 10 and 11 of the Constitution of India permit enactment of Section 6A of the Citizenship Act, in as much as Section 6A in prescribing a cut-off date different from the cut-off date prescribed in Article 6, can do so without variation of Article 6 itself, regard in particular being had to phraseology of Article 4 to read with Article 368(1). Whether 6A violates Article 325 and 326 of the Constitution, in that it has diluted the political right of the citizens of the state of Assam. What is the scope of the fundamental right contained in Article 29(1)? Is the fundamental right absolute in its terms? In particular, what is the meaning of the expression culture and expression conserved, whether Section 6A violates Article 29(1)? Whether Section 6A violates Article 355, what is the true interpretation of Article 355 of the Constitution? Would an influx of illegal migrants into a state of India constitute external aggression and or internal disturbance? Does the expression state occurring in this article refer only to territorial region, or does it also include the people living in the state, which would include their culture and identity? Whether 6A violates Article 14 in that it singles out Assam from other border states, which comprise a distinct class and discriminates against it. Also, whether there is a rational basis for having a separate cut-off date for regularizing illegal migrants who enter Assam as opposed to the rest of the country. Whether Section 6A violates Article 21 in that lives and personal liberty of the citizens of Assam are affected adversely by massive influx of illegal migrants from Bangladesh. Whether delay is a factor that can be taken into account in multiple relief and petition filed under Article 22 of the Constitution. Whether after a large number of migrants from East Pakistan have enjoyed rights as citizens of India for over 40 years, any relief can be given in the petition filed in the present cases. Whether 6A violates the basic premise of the Constitution and Citizenship Act in that it permits citizens who have allegedly not lost their citizenship of East Pakistan to become deemed citizens of India, thereby conferring dual citizenship to such persons. Whether 6A violates the fundamental basis of Section 5(1) proviso and Section 5(2) of the Citizenship Act, in that it permits a class of migrants to become deemed citizen of India without any reciprocity from Bangladesh and without taking the oath of allegiance to the Indian Constitution. Whether immigration expulsion from Assam Act 1950 being a special enactment.
Actually, we've seen those issues. Many of these issues are really shades of the same. They are actually submissions.
Yes.
May I suggest?
Why it is
One second.
constitutional.
I was
So
trying.
We'll not stop any members of the bar from arguing any of these issues. For instance, the 21 argument, the 14 argument, the statutory argument. But those are really the delay. Those are arguments which we'll consider.
That is the position, my lord, we are satisfied.
We'll not.
At
hear
the
it.
moment, we are
If I can
recasting
say-
issues to make it more focused, that's all, brothers. That's all, nothing more than that.
So, but rest assured, once, the only thing which we would now request is that the council on one side may decide who's going to argue which point, so that there's no repetition there.
That we will.
My lord, I was the lead petitioner in the lead case, that is All Assam Sannmilita Mahasangh.
So if all the learned counsel for the petitioners could sit together
We'll do that.
and distribute the issues between themselves so that there'll be no overlap, that's all.
That will do.
And likewise, on
this side,
of the respondents, once you know also what the learned attorney general is going to argue, then perhaps, so that there's no overlap, only to save judicial time and
My lord, from the petitioner side, myself and Mr. Shyam Devan will be there.
Mr. All right, both of you are arguing. And what about Mr. Sibal and,
They are all respondents.
oh, I see.
In one of the order, Lordship has showed my London friend as having appeared for the petitioner. On the first day.
You both of you decide what, who will argue what.
Yes.
Otherwise,
Mr.
There will be no overlapping, my lord.
Testing will be for the respondents.
Yes,
Oh, I see.
yes, we will be.
And Mr. Dave. And this, and the attorney?
Where is the attorney, Your Lordship?
No, no, what about, what would be?
My lord, we will, my lord, accordingly adjust, my lord.
what will
bifurcate the
be,
issue.
what will be your stand? Opposing your petitioner or respondent?
So when, at what
You
point
support
will you
it.
argue? The petitioners will argue first.
Yes, my lord.
Then should we ask the other respondents to
So, my
respond
lord,
first?
then
or-
we would like to, my lord.
Well, I think that the government first must respond to that
Let
and
the
then we will
government,
respond.
fair enough. So that the government, then that will be the order. The petitioners will argue first, then the government will respond, and then all of you can then.
Correct. Well, that will also make, if the government responds and we are supporting them, our arguments will be short then.
Yes,
Because why
exactly.
will we waste the court's time?
That's right.
Millets, there is one more issue. I'm sorry, Millets, I'm just, let's me just,
Supporting the validity
Millets,
affidavit.
there's one more issue, Millets. 6A is silent on the citizenship of the descendants of Millets, those people who had come prior to 71. So, Millets, I had filed an application, Millets, in this matter, in the lead matter. Millets, basically about Millets to determine the citizenship of the descendants, because we would argue that every person born in India will not include descendants of people who are illegal migrants. That would only include descendants of people who are citizens of India or who stayed legally, like refugees or.
All right, we'll consider that.
So that, no, I just wanted to tell you, Lordship, this,
All
that
flag-
application was, my lords, converted to a writ petition.
Then we can take it.
Well, let's.
301.
Page
What
four
you-
of the-
Yes,
Let's kindly have a.
plus
look at-
that writ petition has been referred,
Want Samiran?
that's Deepak Kumar Nath. That is the-
Samiran, what do you want? An
Category.
application or what? What do you want?
Millers, that issue can be framed.
That's part of it. We have already.
That is interpretation of section 3.
Actually, look at page 4 of the submissions that we have given to your lordships, Millet. And paragraph 5.
So that again depend upon what your lordship decides on 6A.
Their status, their entitlement.
Correct, because that's an issue that will arise. And Millet,
That would involve.
depending on how your lordships decide on 6A.
Right, because that's consequential.
That's the only thing. Nothing.
All right, so we'll keep it now at this.
Yes.
So that we'll today, I believe today we'll not be able to start this matter.
Yes.
We'll keep it some other day.
Yeah.
This is 501. So we have now formulated the issue. We'll just indicate the time schedule for hearing this matter a little later, once we know, what is following.
Yes,
some
and
of the other
date and a
matters.
time schedule. Millet.
Yes, date and a time.
Keep it.
Also, you're right. So let's say that within what period will you file the compilations and the written submissions?
1 week.
Within a week or
2 weeks, Millet, 2 weeks.
the?
My lord,
yes,
pursuant
the
to the
written-
earlier exercise, you have already submitted our written argument.
That's
It
how.
will have to be collated,
Okay, okay.
paginated, etc.
The.
May I
written
say, my
submission-
lord, may I make a small submission, my lord? My lord, when the matters were being heard at the earlier round, my lord, some of us had filed interventions, and those interventions were filed in the lead matter with Assam Public Works. My lord, now in this new categorization, our applications, because Assam Public Works is taken in the second category.
No, no, it will be the lead matter, but that's the order.
Will be.
Assam Public Works is in the NRC category. I saw the categorization. Would your lordship, well, I don't want to take too much of a lordship's time. Would your lordship allow us to refile the application in any of these matters? Because ultimately it's only questions of law that we need to address. We'll only support these.
Need not be.
We'll not take.
Refile your application, we'll hear you. I mean,
Yes.
and after the
It's all
argument, the lead
Not
matters
file
are.
any more
Yes, ma'am.
petitions.
So that don't worry, we'll hear you.
My lord, my
we say
submission
that
is
the-
lordship will pass the order in 562, which is the lead.
The written submission.
Joint compilation, which is missing.
Submissions together with a joint compilation shall be filed within a period of 2 weeks.
But can it be 4 weeks? my lord?
No, no, that.
Everyone, my lord, there is a,
All.
Will take.
because, my lord, there are,
All at 3 weeks. Karan. Only thing is that way, once the constitution bench gains momentum, then it's good that we then, sort of go on with this. So 3 weeks, let's do it. For the purpose of collating, for the purpose of preparing a common compilation of bracket 1, precedent, bracket 2, legislation, and bracket 3, documentary material, comma. Who are the two nodal counsel on your side?
Ms. Diksha Rai can be.
Ms. Diksha Rai, learned counsel, and
My friend, Mr. Manish Goswami, they can do the job
and
together.
Mr. Manish Goswami are nominated as nodal counsel.
We are already.
The nodal counsel are requested to prepare the common compilation duly indexed and to circulate them to all the contesting or to all the counsel appearing on behalf of the contesting parties, as well as to the court master for circulation to the judges, to the bench.
Fair enough.
Stop. This exercise shall be completed within a period of 3 weeks. We list it on exactly 3 weeks from today then. That will be, Narasimha, what day? List on?
4 weeks from today, not 3, because we'll
It
then.
will be for hearing or for deciding?
I think then we can start hearing after 4 weeks.
Yes, absolutely.
There's some few, Lord,
7th February we'll start.
That's fine, that's fine.
7th
Yes,
February.
fine.
Yeah, that's fine.
We'll start on the 7th Feb, so at least. That is a basic
Yes.
issue.
Because for the respondent, Fuzail UB was the counsel from our side, but his name should be added, that's all.
So there'll be 3 nodal counsel then.
Yes.
can be.
So long as 3 of you are acting in concert and
Yes, yes,
preparing
they will.
soft copies, that's okay.
They will.
One of the 3 can do that really and circulate it.
Lord, if your lordship can consider, and I leave it at that, Lord, 7th, the 3rd week of February. There are, Lord, few constitution benches, Lord, hereafter also.
Take it on 14th.
We'll keep it on the 14th of February.
Very well. That's an auspicious day.
That's on? That's awesome. That's awesome.
I'll offer a rose to my learned friend on 14th May.
Yes, yes.
Deep.
On 502, your lordship should remember that I raised a preliminary issue, whether it should be referred to 7 judges or not.
Nebam Arabia.
On that, we filed our written submissions. They have filed the response last night, Manoj. So your lordship may fix a day because everything is complete there.
That also is complete.
Whereas in
so-
fact, your lordship had indicated on the last day that your lordship should start with Navam Revia. If your lordships feel it doesn't need to be referred, your lordships will continue with the hearing.
Yeah, that's fine.
The other issue. That's what your
I have no
lordship
problem.
indicated on the last.
When can we list it? Give us some date so that.
Well, as quickly as possible because the election
If
commission.
that is the other matter is on the 7th, my lords, that your lordships have.
No, 14, that's
Not the
14.
14th.
14. So after that,
No, earlier. than
no,
that.
I have no difficulty. I see the convenience of the.
My request is
Earlier is-
earlier because
The solicitor after that.
Can be the week of 7th.
7th.
NCT is now opening today.
Yes.
So NCT will go on this week.
Yes.
So NCT will pretty much take the whole of the week of the 9th, now that yesterday's week that has started. So we can keep this either on the
Third
End
week,
of
4th
third-
week of January.
3rd week of January or
That's fine.
Can it go, my lord? As I requested, my lord, there are few constitution benches before that. Therefore, I requested not 7th, but 14th in Assam. Can it be after 14th?
Well, there is a problem there. Well, the election commission proceedings are going.
Mr.
Well,
Mehta.
I don't want.
Mr. Mehta, as Mr. Sigbal has said, 14 is a very auspicious day. All of you should be at your home rather than here.
We should be, my lord.
Yes, I know. But sometimes they ask us to come here instead. Well,
That's the gift they expect from us, my lord.
do is we can start the Maharashtra, Hima. Maharashtra, we can start. We can start the Maharashtra matter on the 14th and take up the Assam matter immediately after the Maharashtra matter then.
Very well.
Very well, very well.
That would be better, Malad.
That would be better. Because Malad, there is an urgency
So
here.
we keep Maharashtra first on the 14th.
All right.
And then followed by, that will be the Assam matter.
Correct.
Immediately after that.
Yes.
Correct. We'll inform them.
Mr. Yes, just inform your colleagues that.
I'll convey, my lord, the council who came.
So the date is the same, except that Maharashtra will initially be taken up on the 14th.
Deeply.
In fact,
After Maharashtra gets
in fact, my colleague, my lord, who was opposing me in Assam, told me that 14th is his wedding anniversary, but he will have to come here. I said, no, he will be happy, my lord.
That's right.
Okay. So we keep it on the 14th and then 21st and then we continue with.
But we also have, at some point, and we had raised this, sorry, I was in the other constitution bench. To what extent is the matter still alive? And which are the issues your lordship should be addressing? Because yes.
Yeah, that's fine.
We'll have to,
That's all right.
your lordship may have to start from there.
No, we're starting with the main issue, whether it should be 7 to 7 judges or not.
Well, whether that issue is purely academic or whether it's.
That, Malad, that matter will have to
Anyway,
be
if
argued.
we are pressing for a reference, we'll hear both sides of that. So that now is, so Maharashtra then 14th. We start
14th,
Maharashtra on the 14th.
Yes.
We'll hold it down so that we will organize our respective sitting lists accordingly.
Assam
Will be listed on the 14th, but to be taken up immediately after
After
Maharashtra
that,
gets.
correct, Malad. Deeply obliged.
Now the next matter should,
501 and then
yes,
50.
up next matter,
Item 503.
Wait, please, you might.
Grade 4.
NCT now. Uh,
Wait, please.
For my learned,
Your lordship has got.
before my learned friend begins, I just wanted to make a request. There is an interim application, intervention filed by the IS Officers Association.
We'll start.
Ultimately, they are also directly concerned with
we'll
which.
hear you at the appropriate.
After both government will
Really?
finish.
We'll consider.
Yes,
Give me an hour's time to assist.
Let us start. Let us begin the matter.
Yes,
Wait,
yes,
please, my lords. Now, let's your lordship has got the written submissions and a small supplementary one also from our side. Let's not get into the logistics. As we go along, your lordship will see those things. Now, my lords, let me just make a few give your lordships 4 or 5 broad themes which arise and then come to balance. And what I will do is, after the broad themes, I will deal with each section of our written submission only by showing the material and then move on to the next section. And it won't, it'll expedite it in that manner. But there are 4 or 5 broad themes which are important. First, balance, and I'm giving your lordship a summary of my submission. This is a case at the core, not merely about distribution of powers and the balance between Government of India and NCT. As it appears to be, certainly it is that also. But at the core, balance, it is about whether civil servants serving in the NCT are accountable, Malas, through the government ministerial responsibility and then through them to the people of Delhi, which elected the Delhi government. Really at the core is that issue. And when I come to that section, I'll be dealing with some interesting issues, Balas, about how, and your Lordship's judgments have also dealt with it, including one judgment by the Honorable Chief Justice. Your Lordship is broadly a triple chain. Civil servants must be accountable to ministers. That is the first leg of the chain. The buck stops at the minister, he takes responsibility, but they are accountable internally to the minister. Second one is the minister is accountable to the legislature. This is the heart of the whole system. Without that, your entire Westminster system can't function. And then finally, the members of the legislatures are accountable to the people who elected them. This is the triple basis of how the accountability of the civil servants gets fused ultimately with the people who elect the government. The second aspect, the broad theme, in any federal, and I use the word federal loosely, call it quasi-federal, more unitary, less federal. I'm not getting to that debate. I'll be coming to that. Again, a lot of is dealt with. But in any slightly federal, and we are more than slightly federal system, there are at the minimum a dual set of governments operating. Of course, there are municipal, then there is Panchayati Raj. So there are 5 actually, but I'm saying at the level of the sovereignty, there are 2 levels operating. One is the national sovereignty and the one is the state government. Dual operation, dual governance. Well, it's dual manifestation of public will goes along with dual governance. So there is a dual manifestation of public will. My Lord notes the intelligence of the electorate, especially in India. Any number of cases. Your Lordship has a national election, verdict X. Your Lordship has 2 months later a local election or 2 months before a local election, verdict polar opposite Y. Because these are 2 we the peoples. I'm putting it in the constitutional sense. There is we the people, which is all of us, manifesting in governance at 2 levels, at the federal level and at the state level. And therefore, what is linked to that is federalism, which is ultimately a vehicle for managing diversities. Somebody said it's like a pressure cooker. It allows you to let off steam to manage this cauldron of diversities, and India is the most diverse spot on planet Earth. People talk of salad bowl, melting pot. When you come to India, you cannot imagine a diversity more than India, anywhere in planet Earth. Federalism is a vital vehicle for managing diversities. Diversities in governance, diversities in dual governance, and of course the entirety of diversities in language, dress, habit, food, smell, so many things. Thirdly, the third broad facet arising here is any government which is to fulfill the will of the people in this triple thing is answerable to the legislature, legislature is answerable to the people, and the civil servant is answerable to the minister in whose department he works. So the third facet is any government to even exist will have to have the ability A, to create posts, B, to appoint staff to those posts, and C, to interchange them according to that government's perceived sense of that person's efficiency, ability, competence. Unless a government has this power of creating and managing the civil service, appointing persons, transferring persons, the government cannot function. The government represented at the political level by ministers creates policy, creates decisions of a broad nature. But any government, central, state, municipal, whatever, the implementation of those policies depends only on the civil service. Implementation and policy making. Implementation depends on the civil service. Imagine, Manoj, even conceptually, and I'm only at the moment talking conceptually, a situation where those who are charged with the obligation of implementation, ultimately going back to the will of the people, the political executive is excluded from dealing with them or controlling them. So, Manoj, exclusion of civil services power from any government actually negates the very purpose of that government, negates the purpose of giving it any autonomy, negates the purpose of creating by whatever name called local governance or state governance. What happens when you exclude, Manoj? The political system, civil service below, legislature above, people at the back. What happens when you exclude civil service, Manoj? A, exclusion of civil service means that the civil service itself ceases to be accountable to the people through this chain of command which I've just described. So you are negating, you are actually negating at the end of it, we the people. Second, exclusion means a impossible to conceive situation where I, as the ministerial level, am charged with making policy, but those who are to implement it are not responsible to the policy makers. You are a civil servant in that sense, but a civil servant with a different master. Not one is like Shakespeare, a servant of two masters, very famous play. Servant of a different master. Serving in my department, but servant of a different master. Thirdly, and your Lordship knows this better because your Lordship does a lot of administration also as judges. Your Lordship knows that when you have no accountability to those whom you are serving, then Manoj, you function at your own. Ultimately, the person is concerned only about how you write his CR, how you deal with it, how you talk to him. If you know that you are freed from this control, then Manoj, there is complete insubordination. There is complete chaos and indiscipline. That's a natural corollary. At the heart of this case is it even conceivable to argue or suggest, especially after your Lordship's Constitution bench, and I will say that this is a very short case because most of these things are dealt with by your Lordship's Constitution. Is it even possible to contend that civil service be excluded, as has been done by the impugned notification? That's all. The short point in the impugned notification is civil service is excluded from the NCT's control. NCT, when I say NCT, I mean NCT government, not the territory. Is it even conceivable that you can have a notification saying civil service is excluded from the NCT government scope? Then your Lordship might not have created 239 AA NCT. For that matter, your Lordship need not have created lesser. There are 9 union territories in India. One category is no legislature. One category has legislature but by parliamentary law. Delhi is the third category, only one, which has parliament by constitutional amendment. In neither of these two other second categories, even the parliamentary one or the constitutional one, can your Lordships imagine a UT with a legislature, with a government, with ministers, where the civil service from ministerial or governmental control? It might sound well as simplistic or astonishing. That's the heart of this case. That's the notification we are impugning. Then, Malas, and we'll be coming, Malas, in this to that accepted paradigm. Nobody is talking here about, Your Lordship knows there is a joint cadre. Your Lordship knows it's an all India service. And then there are state services. In the all India service also, you are always rooted and anchored in a state. Service is all India, but you don't hang in the air like a Trishanku. You are anchored in Malas, a particular state. So, Malas, the all India cadre decides to release Mr. A or B. Till there is no issue. Once he releases A and B for state NCT or state Malas X, then how that person, where he's posted? Tomorrow, Malas, I decide to post him in my place and I decide to post him elsewhere because I have a perceived understanding of their competence. He'll be better in Department of Storage, he'll be better in Department of Water, whatever I may say. That is entirely an intra-state issue or an intra-UT issue. It can never be an issue which a third party can decide. Otherwise, you can't run any UT. So, Malas, the All India services and the central government services, the two broad categories, are designed to serve state units after being allocated to a particular state. But how they operate, how they implement the policies, where they go, which department, transfer or Malas, keeping XYZ at XYZ places, is entirely an intrastate administration implementation issue. If you do not give that power to the UT or the state, then Malas, it is impossible to conceive of a system functioning. In our discussion, Malas, we had an example. I mean, it may sound like a simplistic example, but it's not an entirely inapposite example. Malas, Your Lordship has a chamber of a lawyer or a senior counsel. He gets, Malas, juniors or Malas, colleagues in the chamber. He has started his practice in a small chamber. He decides that this person's unique abilities lie in this area of law. I will give him this whenever this kind of matter comes, and this person in another kind. Or he will be in Supreme Court, he will be in High Court. I'm giving just examples. The chamber head decides that. As his practice grows, he gets many more juniors. He creates new posts and decides. And tomorrow he decides, no, I found from experience that you are not so good in Supreme Court. You go to Supreme Court, you go to High Court. These are matters of implementation and administration. Your Lordships can't conceive of any system working. Here the whole government is to work without civil services being in their control. By a bizarre interpretation of entry 41. That's the whole case. Not a wrongful, not a bizarre, I use the word advisory in this. And I'll demonstrate that. Incidentally, but just aside, this is aside. When I come to the judgments, including my Lord the Chief Justice's judgment on federalism, I'll read those paras. Most of these issues are decided accordingly. There is no question of much left, but Your Lordship still has to see them. But as an aside, we were, as Your Lordship knows, called a quasi-federal system by that Australian jurist, Kenneth Weir. He says, broadly, you are central with some federating influences. And one of the interesting stories, there is very nice articles on that, shows how we have had inadvertent or accidental federalism or unintended federalism. In actual operation and practice, we are far, far more federal than our creators envisaged, because the Lordship knows our creators were very worried rightly about the fissiparous tendencies of the country. And therefore, they made a centralized unit, more federal than England, but still not as in USA. And as the Lordship knows, in USA, it is a bottom-up. Pre-existing independent countries became the US, Texas, Louisiana. Our case, sovereignty was not bottom-up. It came from within the country. But the beautiful story in India is that in 70 years, we've had linguistic federalism. We've had fiscal federalism. We used to give 30% odd funds to the states. Today, that figure is close to 45. It's 43%. It's going to become 45 soon with all the grants and everything. Linguistic federalism, 356, which is supposed to be the biggest anti-federal provision, its uses after 2000 till today, we are in 22, is not more than 10 times. The answer there is judicial review. The Lordship steps in and decides it much quicker than your Lordship used to do pre-Bombay. Your Lordship either negates it or upholds it, and the fruits, Mr. Hegde lost one Bombay. By the time he won Bombay, after 3.5 years, 3 governments had changed. He never got the fruits of his victory. Mr. Ramakrishna Hegde started Bombay. Today, your Lordships in Rameshwar, in Uttarakhand, in Jharkhand, so many judgments, I've had the privilege of assisting the court, Karnataka twice, etc. Your Lordship's judgment is quick, swift, judicial review is full. Therefore, that again has become a great impetus to federalism. Today, the conscious decision was to create a much more answerable, locally autonomous federal unit in Delhi with a constitutional amendment. And you are negating it full circle by saying civil services are excluded as by the implemented notification. As a matter of fact, it is ironical that implementation by civil servants is fully untrammeled in the municipal corporation. Well, Lordship may not know this, but where your Lordships lives is 42 odd kilometers in Delhi. NDMC area, so-called Lutyens Delhi. Square kilometers. Nowadays referred to not entirely charitably as the Lutyens Delhi.
Yes.
Lutyens Delhi.
Yes.
That has different connotations.
So,
including Khan Market, Delhi, etc. But I'll leave that aside. Now, the rest of Delhi is 1400 kilometers. Square kilometers. And that is MCD. There, civil servants have much more power with the standing committee and the municipal corporation which runs it. But the Delhi government will have no power on civil service. Look, this is going to lead to some remarkable, ridiculous situations. I'll be dealing with them. I'm only giving Lordships some opening facets. Municipal governance is much more rightly focused on implementation through civil servants, which are under the control of 2 entities, the municipal corporation head and the standing committee. But the NCT government, which may or may not control the municipality, that depends on elections, has no such power over civil service. Well, as in the supplementary 8-page submissions we filed, we have also done a global survey, I'll be coming to that, of different forms of state capitals or individual cities. Don't go to it now, but Joshua will just note that we have dealt with countries like Nigeria, Abuja, to Addis Ababa, Mexico City, Washington, DC, and most important of all, London, which is the most centralized country. London is not even an apology for federalism, if your Lordship really goes to the spirit of it. Yet, in the most centralized of these several examples globally, not a single example where even if the control of that city-state is with the center completely, are civil servants excluded from local governance of the entity which governs that city. It is quite amazing. Greater London, by an act, gives the mayor and the bodies which run London full control over the civil service. Although it's a completely centralized system, I'm giving only examples, not that your Lordship knows. By contrast, your Lordship will have a very strange thing. Your Lordship has a 239 AA constitutional amendment to create autonomy, decentralization, will of the people, manifestation of electoral will in Delhi, and a government which has no control over the civil service. So, these are some facets your Lordship will be dealing with as your Lordship goes along in this matter. Now, let me take section-wise these submissions. I know your Lordship would have seen them, but I'll be showing you the material underlying them, each section, then move to the next section. That will be quicker and easier. Now, the first part of the submission is to give your Lordship the narrower and the direct issue arising. The issue is whether under any part of 239 AA, clause 1, clause 2, 3, 4, whatever, I'll be reading them, which your lordships got in through the 69th constitutional amendment. Civil services can be excluded under the impugned notification. Now, I'll just oralize first, then show you these provisions, etc. After the introduction of the 69th constitutional amendment, creating 239 AA, Delhi was given the nomenclature NCT once. Delhi became NCT. It was intended to be and is a union territory. There is no dispute. I'm a little surprised that the respondents have devoted pages in their written submissions, which we got yesterday at 5 o'clock, saying that it is a union territory. That's the admitted position. Nobody is disputing it. Nobody is cavilling it at. The case is it's a UT with the legislature minus 3 exclusions alone. That's a constitutional intent. I will show presently, Malas, and this is a little distressing, that by notification, not even by legislation, they have simply created a 4th constitutional exception without a constitutional amendment. Your Lordship has a transferred subject, A exclusion, 1 land, entry 1, 2 law and order, 3 public order, 1, 2 and 18. Now, Malas, your Lordship has a 4th one by a notification, constitutional amendment be damned, 1, 2 and 18 be damned, the intent of the original famous be damned. But I'm sorry, it might sound a little startling, but this is nothing more and nothing less than that. So, Manas, although it is accepted all along, it's a UT, it's a sui generis UT. It's a sui generis, it's a special, unique UT, where your Lordships, Manas, had decided by the legislature that yes, the concession to it being a capital, suppose a Lordship were creating, Manas, a UT in Madhya Pradesh, your consideration might be different. But because this is the national capital, we should lean for a variety of reasons, which I entirely concede. 3 powers will be with the central government: safety, security, diplomats, diplomatic buildings, countries, foreign ministry. But in every other which way, and there is a 4th power. So the exceptions are, what are these 3? There is a 4th one. 4th one is that in rarest of rare cases, for significant issues, if there is a disagreement between the government and the LG, then he has a power of deciding nothing, doing nothing, referring to the president. That is also written down in 239 AA4 provision. Doesn't require anything your lordships to go into anything. So it's a carefully calibrated, nuanced, stated exception. Okay, we are creating a state, of course it's a union territory, but we are giving it all the powers of a state minus 3, plus minus this reference to the LG, to the president. As I said already, out of 9 duties in India, there is only one with a constitutionally created legislature, Delhi. Parliamentary legislatures are in Puducherry and Jammu and Kashmir. The others have no legislature, which are Chandigarh, Andaman Nicobar, Diu Daman, Lakshadweep, Dadra Nagar Haveli, and Ladakh. The 4th aspect, before I read the provisions, is that there is a further thing given. So I've made 4 points. Now the 5th additional point given in favor of a UT is that Parliament can make laws where Parliament chooses. And suppose Parliament makes a law directly on this bag, it will trump other attempts, legislative or executive by the state, to do something with this bag. But parliamentary power of law to specifically deal with something, and that's the 6th point, does not touch executive power of the NCT, directly held by my lords in several paras in the NCT Constitution bench. Therefore, I'm surprised whether the notification could have been issued. Exclusive executive power of the NCT government. This is the heart of the matter. And on this, Balance, a very strange play is made on entry 41 to come to this present result. Executive power is with you, Mr. NCT. It is not trumped unless Parliament chooses to make a law directly on that subject. Obviously, nobody can violate a law. But otherwise, you, the government of India, do not have parallel executive power where executive power is directly being exercised in everything minus those three lists, three entries by the NCT. And it's held, Manoj, in at least 3 to 4 paras of your Lordship judgment.
Yes.
Now, these are the 5 or 6 nature of the structure of 239AA. With that, Manoj, may I ask your Lordship to first turn to 239AA? Manoj, I will first read for focus 1, 3, and 4, and then read the rest of it. Part 8, you also will turn to 239AA. Well, it's in your Lordship's page 151 of the bundles. Now, your Lordship has made even old horses like us learn all this. So, your Lordships can use that, or Lordships can use the book, no problem.
So, Dr. Singhvi, in the case of the NCT, both now Parliament can enact a law on any subject in the state list also.
Correct.
That's the difference between the NCT and any other state. That in the case of the NCT, Parliament can enact a law on the state list and of course the concurrent list. The union list is of course exclusive to Parliament.
Exactly.
But in relation to Delhi, Parliament can enact a law on any aspect of the state list. So in that case, in that sense, the state list and concurrent list are both concurrent.
Which is why it is a UT.
That's why it's a UT.
It's a UT.
Right. Now, just very interestingly, I mean, this thought occurred when you were making submission a short while ago. I mean, if you see now Article 162 of the Constitution.
162.
The proviso.
Yes.
What happens in the concurrent list? Forget the NCT. Take a case of, say, Gujarat or Maharashtra, Orissa.
This is what is dealt with by a Lordship.
Right. Now, if Parliament is operating in the concurrent list, then what is the executive power of the state in the concurrent list? Because the same principle will apply to the NCT in relation to the state list also, because the state list is also concurrent in the case of the NCT of Delhi.
Provided it to enact.
The proviso to 162. Just see the proviso to 162. Just read the whole of Article 162.
That's a very extraordinary exception.
Yes.
Subject to the provisions of this Constitution, the executive power of a state shall extend to the matters with respect to which the legislature has power to make laws. This is for a regular state, if I may use that phrase. I mean,
so the executive power of the state legislature extends to all
list
2 and list 3 subjects.
Coterminous.
List 2 and list 3 subjects. Now the proviso.
Provided that in any matter with respect to which the legislature of a state and Parliament have power to make laws, the executive power of the state shall be subject to and limited by the executive power expressly conferred by this Constitution, directly by the Constitution, or by any law made by Parliament upon the Union or authorities. Therefore, there are 2 sources. I am for a minute, we'll consider a state, not the UT example, because that's got other nuances. State, regular state, so to say, has got all the coterminous powers of list 2 and list 3. The state, therefore, can exercise all executive power of those subjects. However, there is a particular provision of the Constitution, which I'll just show in a minute, which says executive power on this shall be with the President of India, which is the Union Cabinet. Or it says that I, the Parliament, make a law in a concurrent list. In those 2 cases, the executive power also will be exercisable by the Parliament, but not for these list two in the case of a regular state.
In the case of a regular state, for 2 minutes, my sister just got a sudden bout of cough. We'll just give her.
Certainly,
Maybe have a
certainly,
glass
certainly,
of
of
water.
course.
We'll come back in 5
Yes,
minutes.
certainly.
My apologies, we have to take a break because.
No, I hope your lordship is feeling better.
Oh, yeah, yeah.
Well, it's, the answer to my lord's query just before the break is in 73 and then 239 AA, which I was about to read. Kindly just read it to me, your lordship will get many of the answers there.
Which provision?
Constitution of India, Article 73.
Yeah.
73, then 239 AA after that. Both of them contain the answer.
73.
73. This was executive power, concurrentness and all that. Extent of executive power of the Union, subject to the provisions of this Constitution. So it starts with subject to other parts of this Constitution. And 239 AA is one of those parts. I'll take a look to it. The executive power of the Union shall extend to the matters with respect to which Parliament has power to make laws, to the exercise of such rights, authority and jurisdiction as are exercisable treaty, forget agreements. So the first is law, and this is coterminous, provided that the executive power referred to in A shall not, save as expressly provided in this Constitution or in any law made by Parliament, extend in any state to matters with respect to which the legislature of the state has also powers to make laws. So that proviso is important. Now, Lordship, will just read it with clause 239 AA for a minute.
Yes.
And in fact, this is exactly the balance Your Lordship struck in the judgment, which paras will be, I'll be reading.
So actually 73, the proviso is very important because it shows that even in the concurrent list, Parliament, the union government cannot take over the executive power in the territory of a state.
That I'm very grateful. That is the exact sentence. Even where you can legislate, you cannot denude or take over, as Your Lordship says, the executive power. That's the point. That's the crux of it. It's carried further in Your Lordship's judgment. But first, 239 AA. The Lordship builds on that, not only by.
That's why I take, say, a case like the CRPC.
Yes.
CRPC is in the concurrent list.
Yes.
Code of Criminal Procedure falls in the concurrent list. So, though Parliament has the power to frame the CRPC, the executive power, say in the state of Karnataka, is only wielded by the government of Karnataka. It's not wielded by the Union cabinet.
I'm very grateful. There is a very good reason for it. There would be chaos unless the executive power on the ground, because that's a matter of nitty-gritty on the ground.
But that is, of course, in the state versus.
That is taken care of by 239 and Your Lordship's judgment.
239.
And Your Lordship's judgment. So, well, first I'll read clause 1, 3, 4, etc. Then I'll read the whole of it. 239 AA, part 8. May I read this?
Yeah.
As from the date of commencement of the Constitution 69th Amendment, which is 1st of February 92, the Union Territory of Delhi shall be called the National Capital Territory of Delhi, hereinafter in this part referred to as the NCT, and the administrator thereof appointed under 239 shall be designated as the Lieutenant Governor LG. Now I will read 2, but I want to just focus first by reading 3 and 4, if you will permit me. Subject to the provisions of this, may I read it in sequence, it will be better, otherwise Your Lordship will get disrupted.
Read the entire.
Let me read it in sequence. There shall be a legislative assembly for the NCT, and the seats in such assembly shall be filled by members chosen by direct election from territorial constituencies in the NCT. This was the whole purpose of giving the impulse to the electorate to choose their own people. The total number of seats in the Legislative Assembly, the number of seats reserved for scheduled castes, the division in the NCT into territorial constituencies, including the basis for such division, and all other matters relating to the functioning of the Assembly shall be regulated by law made by Parliament. The provisions of Articles 327 to 324, 327 and 329 shall apply in relation to the NCT, the Legislative Assembly of the NCT, and the members thereof, as they apply in relation to a state, the Legislative Assembly of a state, and the members thereof respectively. And any reference in Articles 326 and 329 to appropriate legislature shall be deemed to be a reference to Parliament. Now, 3A is very important. subject to the provisions of this constitution, the Legislative Assembly shall have power to make laws for the whole or any part of the NCT with respect to any of the matters enumerated in the state list or the concurrent list. So what my lord said is specifically stated there in the act, in the constitution. In so far as any such matter is applicable to UTs. Now this is the entire basis of the impugned notification, falsely and wrongly. Except matters with respect to 1, 2 and 18, that is one exclusion. And mark these next words, 64, 65 and 66, in so far as they relate to the said 1, 2 and 18. So the constitution is very careful. 1, 2 and 18 I am excluding. Others only to the extent they relate to 1, 2 and 18. 3 more I am excluding, not generally. So 64, 65, 66 also will apply to the NCT, will be available to the NCT, but to the extent they are overlapping. Then B. Nothing in this subclause A shall derogate from the powers of the Parliament under this Constitution to make laws with respect to any matter for a union territory of any part. Therefore, for the legislative part is supreme with Parliament. If any provision of a law made by the Assembly with respect to any matter is repugnant to any provision of law made by Parliament with respect to that, whether passed before or after the law made by the Assembly, or of an earlier law, other than a law made by the Assembly, then in either case the law made by Parliament or as the case may be such earlier law shall prevail and the law made by the Legislative Assembly shall to the extent of convenience be void.
This is Article 254.
This is, Manas, has to be, you are already, Manas, in a UT
But
area.
Article 254 in relation to the Union Territory
Yeah.
of Delhi applies even to the state list. Otherwise, 254 applies only to the concurrent.
That is why that distinction, Manas, the supremacy of parliamentary law versus executive power left to the
So
That's the whole point.
is supreme as over the exercise of legislative power by the Legislative Assembly of Delhi, even in respect of a matter in the state list.
Absolutely.
Right?
Absolutely.
Difficulty of
Where they choose.
basic.
And that is not an issue according to us. That is not arising, and that is, Manas,
That's not an issue, absolutely. You're right.
may I just read, Manas?
But this makes a little difference because normally Article 254 gives precedence to a law enacted by Parliament only in the concurrent list.
1 and 3.
Right.
That's the domain. So, Manas, 3 now becomes, as the Lordship knows, that's the difference. Otherwise, there would be no UT. If you did not give the power to legislate in list 2, then it would be a full state.
It would be a full state.
The whole, that's the exact point. That is why, while doing so, they have kept Manas, exclusive executive power separate, as your Lordship is opined, and as is clear from the rest of the article also.
So, though it is a UT, though you have a legislative assembly,
yes,
yet Parliament also has the power to legislate on all the subjects of the state list for Delhi.
But so far the executive is concerned.
Yeah. Yes.
That's the point.
We are now only on the executive power.
Now only on the executive power. And in particular, what are we on? Manas, just give me a minute. The executive power which we are on is the power to create civil posts, transfer people, manage people. That's the narrow issue, as far as this case is concerned. Your Lordship has a second matter at the end of the Constitution bench on some other issues, larger issues that Your Lordship will come to after Your Lordship reserves orders in this. But this case is only civil service, nothing else. Provided that if any such law made by the Assembly has been reserved for the consideration of the President and received his assent, such law shall prevail in the NCT. Provided further that this such law shall prevent Parliament from enacting at any time any law with respect to the same matter, including a law adding to, amending, varying, or repealing the law so made by the Assembly. Now, Manas, 4 is a very, very critical point. Now, note, 4 does not start with Manas subject to. Does my Lord kindly note my point, Manas?
Right.
4 doesn't start with subject to. 73 started with subject to. This
Right.
Constitution. Now, read 4. There shall be a council, it's the exact Westminster model in the executive power. In the executive domain, it's the Westminster model. There shall be a council of ministers consisting of not more than 10% of the total number of members in the Assembly, with the chief minister at the head to aid and advise the LG in the exercise of his aid and advice. This again, a lot of that opined in the judgment. Well, in the old days, when you had a metropolitan council in Delhi, you said aid and assist. My Lord has noticed that. And now it's
aid and advice.
Sorry, assist and advice, not aid and assist. Here it is aid and advice. with the Chief Minister at his head to aid and advise the Lieutenant Governor in the exercise of his functions in relation to matters with respect to which the Assembly has power to make laws, except in so far as he is by or under any law required to act in his discretion. Just pause here. But there are a lot of laws in which the LG is made a quasi-judicial authority or an appellate authority. You will find them scattered across Delhi. Appeal or revision or something lies to him. Obviously, when it's there, your lordship has got a law. He can't be acting on my aid and advice. Provided that this is the fourth exception. I made 4 points. 1, 2, and 18. Then this, then discretion. Now, this is one of those distinctions. Provided that in case of difference of opinion between the LG and the ministers on any matter, now the any matter has to be other than those 3 matters, where I have no power. The LG shall refer it to the President, for decision and act according to the decision given thereon by the President. That can be in my favor, in favor of the LG or otherwise. And pending such decision, it shall be competent for the LG in any case where the matter in his opinion is so urgent that it is necessary for him to take immediate action, to take such action or to give such direction in the matter as he deems necessary. This again, your lordship, is interpreted. Significant matters, rarest of rare, something very, very important. Otherwise, it's an exceptional power. It is not to make Delhi into your own fiefdom without an elected legislature. Your lordship is interpreted as such. And any matter does not mean every matter. That also your lordship minister is one. The chief minister shall be appointed by the president, and other ministers shall be appointed by the president on the advice of the chief minister, and the ministers shall hold office during the pleasure of the president. Very important is 6 words, although only 1 line. The council of ministers shall be collectively responsible to the legislative assembly. This again is one of very important laws to deal with collective responsibility, which means the same tripartite arrow which I said. Civil service is the base, accountable to the minister, minister accountable to legislature, legislature accountable to people. That's the larger concept of collective responsibility. Your lordship now has a recent judgment, which actually relies on Justice Chandrachud's judgment in the other matter. That 2 weeks old judgment refers to that. So it's enough to read the NCT matter itself. Parliament may by law make provisions for giving effect to or supplementing the provisions contained in the foregoing clauses, and for all matters incidental or consequential thereto. Again in law, any such law as is referred to in A shall not be deemed to be an amendment of this Constitution for the purposes of Article 368, notwithstanding that it contains any provision which amends or has the effect of amending this Constitution. The provisions of 239B shall, so far as may be, apply in relation to the NCT, the LG, and the Assembly, as they apply in relation to the UT of Puducherry, which is one of statutory, not constitutional, the administrator and its legislature respectively, and any reference in that article to clause 1 of 239A shall be deemed to be referenced in this article or article 239AB as the case may be. Your lordship will leave that for the time being. Whereas 239B is basically ordinances by the administrator when he needs it. It is clear, therefore, in my humble submission, and that is, let's not say clear, it's my submission to your lordships, that a conjoint reading of these provisions, Head 73, makes it clear that legislative power with which we are not concerned is one category, and executive power is untrammeled unless you choose to make a law directly on that subject and occupy it. Now, just to...
Sorry, what is the last point which you made, Mr. Dr. Singhvi?
Well, I'm saying the reading of these provisions makes it clear that legislative power is in one category. But executive power is not trammeled by the provisions I have read. And indeed, reading in addition of 73 gives your lordships a clear view. And in particular of 239AA 3 and 4. 239AA 4 is the most important. 4 says that there shall be a council of ministers it shall have full aid and advice to LG. One exclusion is 1, 2 and 18. One exclusion is difference of opinion, reference. Third exclusion is discretion, where you are an appellate body or such. Broadly, that's the structure. In other ways, in every other ways, you, Mr. NCT, will function untrammeled in your executive.
There's only one caveat, Dr. Singh,
Yes, yes.
because that is going to be the heart of the case. If you see, clause 4 of 239 AA
Yes.
says that the Council of Ministers shall aid and advise
With the Chief Minister at the head to aid and advise the LG in the exercise of his functions in relation to matters in respect of which the Assembly has power to make laws.
Right.
I have to say that because 1, 2 and 18.
Now, therefore, therefore, what is the extent of the executive power of the Council of Ministers to aid and advise the CM in relation to matters with respect to which the Legislative Assembly has power to make laws? Now, which is the article which tells us the area over which the Legislative Assembly of the NCT has the power to make laws? That is Article 3A, Sub-Article 3A.
3A. All except 3.
Now 3A.
Yes.
Now 3A has two qualifications. The Legislative Assembly of Delhi has no power to make laws with reference to entries 1, 2 and 18. Right?
And 64, 65, 66
insofar as they relate to 1 to 18, as we saw, is public order, law and order and land. So your executive power as the government of the NCTD does not extend to 3 subjects. But when it says with respect to which the Legislative Assembly has the power to make laws, there is one more caveat, which is 3A. Again, if we go back to 3A, with respect to any matter enumerated in the state list or in the concurrent list, insofar as any such matter is applicable to union territories. So, if a matter in the state list or concurrent list is not applicable to the union territories, then you have no power to make law. And because you have no power to make law under 3A, you have no power, you have no executive power over that particular subject.
This is the case set up in the...
Now, whether services falls within that description is a separate issue. We'll deal with it independently.
Yeah.
But as a matter of first principle, therefore, the executive power of GNCTD does not extend to entries 1, 2 and 18, 1. 2, the executive power of the GNCTD extends to all other entries in list 2 and list 3.
Insofar as they...
Right? But 3, it will not extend to all other subjects in list 2 and 3 if it does not, if that entry is not applicable to union territories.
So therefore, Malas, the immediate next...
Now, one more very important thing.
Sorry.
3A uses the expression union territories.
Yes.
Territories. It does not say union territory of Delhi. So we have to find out whether a particular entry in list 2 or list 3 has no application to the union territories in general. Because Parliament has, the statute, the Constitution deliberately uses the expression union territories. Yes. So if any entry in the state list or the concurrent list does not apply to the union territories, then the Legislative Assembly of Delhi has no power to make a law with reference to that particular entry. And because you have no power to make a law with reference to that entry, you have no executive power over that entry.
Therefore, Malas,
now, the only point which we really, the whole crux of this matter is...
meaning of insofar as applicable.
Is insofar, what is the meaning of insofar as...
That's the next section of my submission.
Applicable to union territories. Applicable to union territories.
I've explained in the next section that insofar as applicable is actually a term of enlargement, not restriction. The reason it was necessary was your lordship would have to amend each item of the 7th schedule, which otherwise applies to states, state as in S capital, and would not apply otherwise to UTs. Because normally under 246, your lordship knows a state is not a UT. Well, under 246, normally a state is not a UT and a UT is not a state. Now, this was like a mutatis mutandis phrase. When you gave special power to Delhi, when you created a Delhi of 239 AA, you intended the entire panoply of executive power as per list 2 to apply to it. But you could not amend every entry of list 2. You actually made it mutatis mutandis that what applies to state applies to you also minus 3 exclusions. That's coming next verse. Your Lordship may just park that point as my submission. And that in fact takes away the heart, the entire heart of the notification is that only. Impute notification. So, Malas, what is actually meant to facilitate the creation of 239 AA Legislature Delhi, saying that all the powers which are listed by me in the 7th schedule shall be available to you without my amending the 7th schedule and saying and UT. That is meant to now, read to now mean that they will select notification wise. Well, there are some for 50 entries in list 2. Take away 3. Balance 47. They will select. Today they collect out 1, entry 41. That we decide that service is not available to you. Tomorrow they'll pick up another entry and say that entry is not available to you. Because the word insofar as means that I, the government of India, decide that the subject is not available to you. That's my lord is absolutely right. That's the heart of the matter. But it will become clear. My submissions deal with that directly.
It's not through the notification that you go to the legislative entry. If we could identify through the legislative entry of list 2 that some entries are not falling within the remit of a union territory. If at all, we'll have to examine to see which of those entries in list 2 which will not fall within the remit of a union territory. We will have to identify them if at all.
I will show that my submission is, as a matter of interpretation, your lordships have partially already interpreted that your lordship does not go entry-wise. The idea is, let me just oralize for 2 minutes. The idea is that a UT is being created akin to a state, but with special powers given to the parliament. Put it other way around, a UT with legislature with limited powers is being given. Either way. Now, we, the constitution makers, have decided in our wisdom that 3 specific powers we are excluding. After that's exclusion, that's a very important part of a lordship's interpretation. You decided to exclude. Then we added a further exclusion that where there is a difference of opinion between you, Mr. Singhvi, and him, then one is reference to precedent. Then we decided a 4th exclusion that where there is something in your discretion, that also I can't aid and advise you. Beyond that, to say that you will decide on the basis of the phrase insofar as is wrong. That's the submission. Now, I understand my lord's query, well, I'll be dealing with that, but just kindly bear with me. Now, let us go first, just because here, to just possibly it can be called digression, but it's because I'll be coming to the judgment again and again. Would my lords just see 3 paras of that judgment on this first part of the interpretation of this article? May I just first read my written submission where the notification is quoted? Quoted. First, see what they are doing. What is the reasoning in the quotation? Let us see that. Come to para 4 of my submissions file. I have not read the impugn notification yet.
You are reading your written submissions? Written submission?
Actually, the impugn notification is in the file, but it is reproduced in my. Yeah. So it is easier to use that.
Page 4.
Para 4, page 4. I mean, the relevant portions. But all your lordships can go to bookmark number 2, whichever your lordship prefers.
It's extracted here.
Relevant part is extracted. May I read it?
Yes.
This was issued in 2015. And whereas 239 AA inserted by the Constitution 69th Amendment provides that the UT shall be called the NCT and the administrator appointed under 239 shall be designated as the edge. And whereas 239AA3A states that the Assembly shall have power to make laws for the whole or any part of the national capital territory with respect to any of the matters enumerated in the state list or the concurrent list, insofar as any such matter is applicable to union territories, except matters with respect to entries 1, 2, and 18 and 64, 65. I'm sorry, Honorable Chief Justice.
Yeah, sorry, I missed that actually.
So, may I just very quickly read it again?
Yes.
And whereas 239AA inserted by the Constitution 69th Amendment provides the UT of Delhi shall be called the NCT of Delhi, and the administrator thereof appointed under 239 shall be designated as the H. And whereas subclause A, 3A, that is 239AA 3A, states that the Assembly shall have power to make laws for the whole or any part of the NCT with respect to any of the matters enumerated in the state list or in the concurrent list, insofar as any such matter is applicable to UT. This is my highlighting. Highlighting is mine, honestly. Except matters with respect to entries 1, 2, and 18 and entries 64, 65, 66, insofar as they relate to so and so. And whereas subclause 3A of 239, exactly what my lord read, also qualifies the matters enumerated in the state list or in the concurrent list, insofar as any such matter is applicable to UTs. Under this provision, a reference may be made to entry 41 of the state list, which deals with the State Public Service Commission, which do not exist in the NCT. This is the entire case. State Public Service Commission is envisaged. I may not have enacted it. I have the power, I have not enacted it. It doesn't exist, so you have no power. As your Lordship has another line of cases I've cited. You have the power, you have not exercised it. It's irrelevant. Here they say you have the power, the entry itself says so. You have not created a State Public Service Commission, therefore you have no power in civil service. Kindly read on, this is extraordinary. Kindly bear with me. Yes, yes. Exercise and existence are conflated. It's just the other way around. The existence of my power is important, not the exercise. And whereas it is well established that where there is no, now they mix up this. There is no legislative power, there is no executive power. This is the crux of the error, Manas. This is the crux of the error. Then, Manas, there is no NCT. Why did you create NCT? Manas, kindly bear. I mean, your Lordships, I'm astonished. This is after your Lordship's 2018 judgment. Just kindly bear with me, let me repeat this para. Just 3 lines. If this para is correct, read it any which way your Lordship would. Can 239AA exist? With great respect and humility, no. Effectively, it can't. The entire intent of creating and of separating legislative and executive power is gone. This is actually the real one. So I'm saying this is a patent error. And whereas matters relating to 1, 2, and 18 of the state list being public, so far as they relate to entries 1, 2, and 18, now, just see, kindly, I'm sorry to be a little slow here. The first 4 lines of the last paragraph on 2 and 18. Now the 4th exception is created by an executive notification without a constitutional amendment.
Excluding entry 41.
I'm grateful, kindly read. As also services. Services is on par with 1, 2, and 18. 1, 2, 18, and services. On what basis? The previous line. And whereas it is well established, there is no where there is no legislative power, there is no executive power. Since executive power is coextensive, well, we don't have to be taught by this notification what the Lordship said in Ram Javaya in 1955. But does that mean that Ram Javaya anticipated 239AA in 1992? Services also, added, fall outside the purview of the Assembly of the NCT, and consequently the government of NCT will have no executive power in relation to the above, and further that power in relation to the aforesaid subject vests exclusively the president or his delegate, the president. Now just pause here. Kindly note down, if you're not here, the things arising just from a textual reading of this notification, the impugned document. Number one, it means I have no civil service power, zero. Let's call a spade, let's come down to the crux of it. Forget what your lordship will hold. I'm saying what is the result of this language. That's one. Two, I cannot create a post. I cannot transfer A to B from post A to B. I cannot do anything in relation to a civil service. As a matter of fact, read as it is, I can't pass a law on civil service also. Number three, the basis is that where you have no legislative power, as my Lord the Chief Justice said, because the entirety of list 2 can also be legislated by Parliament. But because it can be legislated by Parliament, you have no executive power, Mr. NCT. That's number three. Number four, if this is so, then there is actually a negation of 239AA and the creation of decentralized governance by the popular will in Delhi. Number five, it is put like that, it is not mine. 1 is excluded, Mr. Singhvi, 2 is excluded, 18 is excluded, and also service is excluded. That's what they say, I'm not saying it. And last, I will put number 6. Actually, it's a small point compared to what is already the first 5. Another source of my saying so, says the government, is that insofar as means that, well, this is very interesting. Insofar as what my Lord Justice Narasimha just observed, very interesting, apropos that query. Insofar as means that even if you have an entry in list 2, which enables the Delhi Assembly to pass a law, your Lordship knows Delhi Assembly passes laws every day. My written submission has shown your Lordship, I'm going to come to it, 20 laws. Even though the Delhi Assembly can pass a law about civil service, State Public Service Commission, etc., because it doesn't actually have a law. Therefore, insofar as applicable means of power is denuded, excluded. Therefore, I will control the civil service. These are
which would be the matters, just looking at 3A again.
Yes.
Insofar as any such matters applicable to union territories, can you give us some examples of which are the matters which are not
well,
applicable?
actually, I'm sorry. No, there will be none.
That's not available.
Let us see. Let us see if there are any entries which will not be within the remit of a union territory at all.
My answer would be none, but let us see.
We'll have to see.
Let us see, yes. Look, just give me a second. As your Lordship sees it, the answer is none because the purpose of insofar as is not this. The purpose of insofar as is that whatever applies to a state will apply to a 239AA. We don't want to repeat in 7th schedule. The purpose of insofar is just the opposite. Now come to I'm just, if I may digress and go to the 7th schedule. My lords ask conceptually, what I understand my lord's query is conceptually or definitionally, what is it that can not ever fall per se? Suppose defense of a naval installation or some foreign relations or treaty. All is coming under list 1. Now let's see. 1, kindly come to list 2. Please remember my caveat, fellows. The object of insofar is just the opposite, nothing to do with this. But I'm still reading it, apropos my lord's query. List 2, state list. Public order, but not including the use of any naval, military, air force. My lord understands that. Out.
Anyway,
2, police, including railway and village police. I'm sorry, Justice Murari taking a hand.
Yes,
Out. Now come from 3 onwards. Officers and servants of the High Court, procedure in rent and revenue courts, fees taken in all courts. Your Lordship's court is rightly excluded already. How will you exclude this? prisons, reformatories, postal institutions, other institutions of like nature. How will you exclude this? Local government, that is to say, constituted power, municipal corporations, improvement, trust, district boards, mining settlement authorities. This may be only excluded partly because of a central law passed. There is a central law which creates the MC. Otherwise, no. My lord is on a different question. If I understand rightly, I may be wrong. Conceptually, which entry can't be available to a union territory? None. Then 6. Public health and sanitation, hospital and of course, one or two of these have a direct law of parliament. They say you will create an MCD. Now they have a new law, delimitation. You'll have 72 wards instead of 52 wards. That's an occupied field. We're not concerned with that. Nobody's fighting that. But your lordship is concerned conceptually. Will you exclude any power from this for a NCT? Kindly go further. Pilgrimages. Whereas NCT has a scheme now to send people on pilgrimage on 3 or 4 well-known circuits. Actually, there's a scheme going on.
Not outside India.
Outside NCT, obviously, there's not much pilgrimage available inside NCT. Sending to Varanasi circuit, called the Buddhist circuit.
That is not the subject matter. Why should
Yes. Intoxicating liquors. Lordship has heard a lot about that recently. Relief of the disabled and unemployable. Burials and burial grounds. Libraries, museums, similar institutions controlled or financed. Ancient and historical monuments. And I'm reading it, in deference to your Lordship's query. My preliminary objection is different. Insofar as it means something totally different. We'll come in a minute.
I understand. Alternate.
Communications, that is to say roads, not the national communications. Roads, bridges, ferries, means of communication, list 1, municipal tramways, ropeways, inland waterways, subject to provision of list 1 and list 3. Anyway, it is subject to. Vehicles other than mechanically propelled vehicles. Your Lordship has the licensing authority under NCT, for example. You don't go to the central government for licensing. Agriculture, including agricultural education and research. Not much in Delhi, but its power is here. I'm sorry, my lord.
Sincere apologies for
No, but
Mr. Solicitor, sincere apologies to all of you.
No, my lord.
not at all.
There's some things which, just overriding administrative issues that the Chief Justice has to deal with, and then
That is, my lord, really an almost equal burden, if not, my lord.
Now, it's, during the lunch break, what I did was I jotted down what are now coming to 12 points. Stay. The query,
yes.
which your lordships had raised pre-lunch. They are scattered all over my written submissions already. Now I'll tell them the same thing in a different way. 1, 2, 3, 4. Lordship, I believe would have all the answers, and your lordship would ask the questions after your lordship appreciates these 12 points. I think they will cover the entire conspect so far, etc.
So you'll read the written submission.
They are there already, but they are not in this 12, 1, 2, 3, 4 points. When I read at the end, it will be all covered. Lordship, I want to just jot down very briefly the points as we go along, subject to my lord's time discussion. Now, the point we are discussing is what? Insofar as is a term, I'm putting the point against me, is a term of restriction, inhibition, circumscribing it. And what does it mean generally for union territories, as my lord the Chief Justice put it? And then related question for civil service for Delhi. Now, the first of those points is that insofar as was put to deal with the accepted legal position that under Article 246, the 7th schedule is created under 246. And under that it is established from age old that state does not include union territories. That's point number 1. Let me give it out to the points. It is to make sure that entirety of 7th schedule under 246, state does not include UTs. And if this insofar as was not then given to equate, you would need to amend the whole 7th schedule. That's point number 1. Point number 2. This position restricted to 246, not generally, 246 7th schedule, has been adopted by my lords in many judgments. The most famous is Kanyan, which I will, this is all there in my submission, but I'll read it. 1969 judgment. For the purpose of 246 distribution of legislative power, state is not UT. And to get over that situation, which would include amendments across the board. Number 3, incidentally, I checked up, it would be a bizarre situation because amendments under 368 of the Indian Constitution, in this case would require 50% of the states agreeing also, because the Lordship knows, if you touch any list, including list 2, 3 and 1, or any minor amendment, theoretically you require 2/3 in parliament, 50% of states. That's point number 3, under 368. Point number 4, in any event, your lordships, both your lordships, my Lord Justice Chandrachud, as he then was, in para 461-463 of the Constitution bench, has specifically dealt with this and approved this. It is not res integra, and there is nothing wrong or erroneous about that conclusion. That's point number 4. Point number 5 is that slightly more indirectly, the judgment authored by Chief Justice Deepak Mishra, as he then was, repeatedly in 6 paras concludes that there is no inhibition to be read from 3A and 4, other than the exclusion of those 3 items, 1, 2 and 18. Clearly suggesting that all these other, and notes the argument of insofar as, notes the argument, and those paras of Chief Justice Mishra's judgments are 204, 219, I'll be taking your lordships immediately. I'm only giving the points. 219, 222, 224, 245.
Which are the paras?
Your Lordship's paras are
And that we got,
461 to
yes, that, and Justice.
Chief Justice Mishra's paras are 204, 219, 222, 224, 245, and most important, the conclusions is 284 dot 14, 15, and 16. One more para I will add where the specific contention is noted, specific insofar as, that's para 39 of the Government of India, contention of the Government of India. Same contention as today. The seventh point, I don't want to go through the whole list, Your Lordship has seen. There is nothing conceptually or definitionally something so alarming in list 2 that Your Lordships cannot contemplate Delhi having that power. I've already gone through half the list, but I can go through the whole.
I missed the sixth point. The
sixth is that para 39 which I put separate.
Okay.
Where the contention. My Lord is right, absolutely. That's a separate para because he notes the contention. My Lord is right, I did not give a number to him. Seventh is conceptually. Eighth is very important, Malas. I am asserting a full legislative, I meaning NCT government, a full legislative power to legislate under entry 41, as I can do under all the items. Delhi Assembly has passed laws under every item. Like that, I have a full legislative power under entry 41. The fundamental error, even as written in the impugn notification, is to confuse and conflate the existence of the power, which is undeniable, but point out to the possible absence, alleged absence of the exercise of the power. There is another line of cases I'll be giving under this eighth point where Lordship has repeatedly said existence of power, then your Lordship is not bothered about exercise of power. Once you have the power.
Does the Union Territory have a consolidated fund? It doesn't, no? It does.
So NCT, yes, sir.
It does.
All these civil servants, by the way, Manoj, are paid for by the NCT. Even, I'm sorry, your Lordship's query has another dimension to it. Please don't misunderstand. Even today, with the LG asserting a power to create a post, appoint a post, transfer a post, it is nobody's case that the entire thing is not paid for by me.
The reason I asked was...
Appropriation bills are passed by the legislature of my state.
The reason I asked was entry 42 says state pensions. That is to say, pensions payable by the state or out of the consolidated fund of the state. Similar to entry 41, it says state.
We pass an appropriation bill. We have the same consolidated fund, the analogy. There's no difference. Except it's called, obviously, consolidated fund of the capital.
What about the salaries and allowances of the ministers?
Of course. Budget allocation, same thing.
The reason I ask is there again, there is entry 40, salaries and allowances of ministers of the state.
Correct. So therefore, Malus, on analogy or principle, then Malus, we can go anywhere. Because Malus, each of the, Malus, we don't forget.
Delhi also undertakes a public debt, right?
No. Yes.
Now, I want to say something.
Yes.
Entry 43 is there. Give me a minute. Whereas it is common ground that Delhi has an assembly. You've created an assembly for all the other 8 duties in India by 3 of them only by parliament law, for us by constitutional amendment. It is common ground that in all several entries, I have passed laws. Every day the Delhi assembly meets, it is meeting now also, I believe, in the next few days. They pass normal laws. This truncated vision of Delhi assembly not being able to pass laws is provided in 1, 2 and 18, that's all.
But Dr. Singhvi, you will have to concede one thing,
yes.
And I'm not making you concede it,
yes.
That because this actually fell in a conversation with my learned brother, Justice MR Shah mentioned this. Entries 1, 2 and 18 are outside your purview, right? Now, if the civil servants are posted in relation to 1, 2 and 18, then it will be outside your executive power also.
Well, I would not like to concede it. It doesn't arise in this case. In the sense that I can't exercise a power about land, about public order and law, But let me, I mean, I don't think it really matters to me, but I'll have to reflect on it. Because
So if a civil servant is sent on deputation for dealing with the land aspect.
Yes.
Suppose revenue officer.
I understand your lordship's query. Your lordship may park that point. That's a valid point because now your lordship is extrapolating 1, 2 and 18, then 64, 64, 5, 66, which is in relation to 1, 2 and 18. Now your lordship is saying even something done directly. But kindly note, when the constitution framers wanted to do this, apropos Justice Shah's query, they were careful to limit it to 64, 65 and 66 insofar as. So they saw the entries as limited to that. Kindly see that, that's important, apropos my lord's query. That's it, fellows. 239 AA bracket 3 bracket A. 239 double capital A bracket 3 bracket A.
How is, now should we go to the judgment?
So, Manas,
Should we go to the NCB
Manas,
judgment?
No, I want to finish my 12 points. Manas. I'm on the 8th point. Just give me a minute. Now, first thing is I'm only digressing to say, on a theoretical basis, they were conscious of the query raised by my lords. That yes, 1, 2 and 18 can have a penumbra of related things, but we are pointing out in our constitutional text 6, 4, and 64, 65 and 66. It's not general. Because you cannot really say that entry 100.
Dr. Singhvi, on a lighter vein, light travels faster than sound. And sound travels faster than a judge's typing. So I'm trying to keep a pace. And I've recorded 5 out of your 7 so far. Now, two have got lost somewhere on the way. You know, come back after something. Between Dwarka and Tilak, it got lost somewhere in one of the turns.
Figure recording subsumes. So well, I'll be very quick. Let me itemize. So well,
No. What Chief Justice says, don't be too fast. You say you will be too.
Oh, I see. I thought my lord is saying to be faster.
No. Out of your 8 points, after your 8 points, I've got 5.
I'm sorry. I'll not take that.
No, don't
I
be
want
so.
to make sure. I want to make sure lordship has got all the points. That's important. Well, firstly, just to leave it on this point, I'm not giving my points back. Whereas your lordship's query, please remember, police and public order anyway will go together. Police comes with largely a central government favor. There's nothing much I can do. There may be some very, very lower level officials which I can't concede without knowing the facts. But it comes. There's nothing I'm told. I'm told we have nothing.
Now, Dr. Singhvi,
Number 2, land. Land you have in Delhi. Not only is land with him, but there is a land agency here, DDA, which when we started practice, we used to call it don't do anything authority. Now it's doing very good for sports complexes. We don't call it don't do anything authority. Well, DDA has a very large remit on land in Delhi, central agency. So, where your lordship's query will arise will be minimalistic, but before I answer it categorically, even for the minimalistic phase, give me the overnight part to reflect on it. But now, just to very quickly itemize and make sure lordship doesn't
LNDO both.
LNDO is even equally important for some more valuable land. DDA has got the common land also.
Yes.
LNDO and what we used to call Nazul land in Delhi. Lordship knows Delhi High Court has dealt with all those cases. Well, it's Nazul land, again, anyway central government. Nazul in fact means central. The word itself has the origin in central. Now, my points were 1, 246 is what makes 7th schedule. I have not yet shown the 7th schedule. The top line of 7th schedule says bracket article 246.
Right.
Under 246, it is established from inception that state is not unique.
Tomorrow you give your 1 to 12 in a separate page.
No, of course I will. But
Over and above your written submissions, you give on a separate page 12 points which you are
certainly.
So that we may not miss anything.
No, certainly. I'm obliged to do that and I shall do it. Number 2, this position in 246 from inception is fortified by Tanian's judgment. And further accepted by lordships many times, including NDMC, that state is not duty. Third, the effect of this is that you would have to amend the entire schedule to add duty when you created Delhi, unless you used insofar as. That's the third conclusion, sequitur. And in that sense, it is only akin to mutatis mutandis. It is akin to mutatis mutandis. Number 4, I strongly object to this government's interpretation or suggestion that your lordship has got words of limitation. These are words actually of facilitation and expansion. It's just the other way around. And that, according to my reading, is the approach of my Lord Honorable Justice Chandrachud in para 461 to 463. That's the fourth point. That's the fourth point. And of my Lord Chief Justice Mishra. That's the fifth point. In the 5 paras I gave, 04, 219, 222, 224, 245, and 284.14, 15, and 16. The sixth point, which my Lord would have rightly missed out, is arising from Justice Mishra's, but I gave it a separate point. He noted the contention of insofar as directly the same contention. And by not giving relief on that basis, well, it's clear that he negatived it. That's para 39. That's a separate sixth point I made. Para 39 of Chief Justice Mishra's judgment. The seventh point was, Malas, I've taken a lordship through the list halfway through. Conceptually, there is nothing alarming or earth-shattering about list 2, which NCT as a 239 AAUT cannot have. Now I was on the 8th point, Malas. The impugned notification directly, Malas, conflates to suggest that entry 41, because you have not passed a law, which I fully assert my right to. Entry 41 gives me the right to pass the law. You have no, and I have passed many laws relating to civil services, which is ignored, which I have put in my written submissions. But that will denude me of dealing with civil service. That cannot be a conclusion.
You can, Mr. Singhvi.
That's my 8th point, entry 41.
You can constitute a state Delhi Public Service Commission. That's your submission.
I can, that's one. I fully assert.
Legislative competence for constituting the Delhi State Public Service Commission is there, according to you.
And the existence of the
Over and above that, therefore, you are also having the legislative competence for constituting State Public Service Commission. There is nothing which derogates from that.
And third sentence is the same formulation, that obviously that nothing can derogate from dealing with the civil service. That's one of the corollary naturally.
In fact, Dr. Singhvi, if we read the expression, those words in that
Insofar as.
239A, insofar as may be applicable.
Yes.
To exclude all entries in the state list where the word state is used. Suppose the logical corollary according to you is
list 2
that wherever the word state is used in the entry in the 7th schedule, the Legislative Assembly of Delhi will have no jurisdiction. That means a whole host of other.
We will have nothing, Malas. Let's be very frank. Barring a few minor inconveniences, nothing.
Take salaries and allowances of the ministers of the state. You can't legislate on it because the word state is used. State Public Service Commissioner Justice Narasimha said, state pensions,
Lordship, please.
Public debt of the state.
Lordship.
All these things will completely go out of the, and there's nothing intrinsic to show that, you can't legislate on, according to you.
And I have given a chart in my written submission, where I have stated all the areas where the word state is used. I have listed, 1-5 of my written submission. I've given a list. What my Lord is just saying, I've culled out and put in a list in para 15 of my main written submissions.
Just to, Lord,
it will be worse than Malas.
It's just to save time. It's not my case that the word state would exclude the power of the Legislative Assembly of Delhi. That my Lord Justice Chandrachud has dealt with in the Constitution bench. That expression being used would not be determinative. It will have to be decided contextually. That's what your Lordship says. I'm not saying, my Lord.
We are not, that's not your,
That's not my submission. So, my Lord, it may not.
that we need not.
Then, Malas, That
So
covers
therefore,
item
the
two, Lordship.
contention of the solicitor would be that, well, of course, we'll hear the solicitor on that contextually, in the context, in the backdrop of entry 41, that power is not available to the.
So Manoj, my learned contention is twofold. Give me just 30 seconds diversion. Come to the notification at page 4 of my.
Party.
Manoj, 30 seconds there. Come to page 4 of my written submission where the notification is reproduced, the impugned notification. His contention are entirely two only. Kindly turn to the notification. They are written in the notification. His case is set out. One contention is the completely erroneous paragraph, which is the penultimate para, which I am reading now at page 4 of my written submission. And whereas it is well established that where there is no legislative power, there is no executive power, since executive power is coextensive with legislative power. This is his first basis. Which means that because for a UT, Parliament can or may legislate, therefore the UT has got no executive power. I am asserting full legislative power. I am asserting full executive power. We are not concerned with hypothetical situations where the government of India has done nothing. I am asserting entry 41 full legislative power and therefore also executive power. Second argument of the learned solicitor is the previous para, which is stated by my underlining, the previous para. Under this provision, a reference may be made to entry 41 of the list, which deals with the state public services, state public service commission, which do not exist in the NCT. Because tomorrow I pass a law and they exist, your lordship, law will change today, what your constitution has decided.
But Singhvi, coming back now to the nature of the services, we have to have some little actual clarity on
And
what
all
are
India
the-
service, central government service,
Right.
they are posted.
Now, exactly. Which are the services which are deputed to the union territory?
All India service.
One would be
central
like
government-
IAS, IPS, which is the All India service.
There are some central government services by other names called, other than All India service. DANIPS are the two most famous. Actually, they are the most sought after ones.
DANIPS would be?
Delhi, Andaman, Nicobar Islands Civil Services. And DANIPS is Puducherry. Oh, sorry, police service. Police service.
So these are all central services.
But always anchored in a state.
They're all anchored in a state.
Well, the person, suppose I am a serving officer in Ministry of Petroleum in Delhi, central government. I'm an IAS. Whether I can be relieved from petroleum and posted to Delhi will be decided by a board which creates these things. A request comes from Delhi. Please post Mr. Singhvi in our post. He says he's occupied, he can't be available, he can be available, etc., etc. Third level is his own personal convenience, which is not such an important level. He is then posted and released to the Delhi. There is a collaborative stage of the central service releasing under a board system. This is happening for the whole country, but this happens to states also. Nothing special. Once he enters Delhi, then where he'll be posted, whether he'll sit as the minister of, under the Ministry of Culture or Ministry of Sewerage or Ministry of Water. After 6 months, not finding him suitable for water, he's transferred to sewerage, disciplining him, passing orders, getting the NCT government's policy to clean the Yamuna implemented through him, finding him not suitable and getting it implemented through him.
Now tell us one.
These are nothing to do with the central government. You are not an officer of the NCT.
But Dr. Singhvi, now take a case where a central officer,
yes,
an IAS or IPS officer is sent on deputation to the state.
Yes.
Because that's his cadre, so, or her cadre. Now that officer goes to the state of Telangana. Once that officer is sent on deputation, the state of Telangana will decide where that officer will be posted, will exercise all of the control over that.
Deputation. There are two levels. One is cadre, one is deputation. His original cadre will be Telangana. His original cadre has to be a state.
Examination. If you are talking of denomination.
Direction. You are always born in a cadre. ultimately when a lordship fills up the form and has the final exam, you give your choices, cadre 1, cadre 2, cadre 3. You may get third choice, second choice, first choice. Having got choice of Telangana, the cadre state is Telangana.
Right.
You will then go on deputation anywhere in the country, including the central government.
Right.
So, but your anchor remains that. Similarly for NCT, people are choosing Danics and Danics. Sorry, not Agbot. The cadre for the centre is Agbot. Arunachal Pradesh, that the whole thing, yes, correct. Because that's the central government service. The other one is
UT cadre, they can be transferred
Anywhere in the UTs.
anywhere in different UTs.
So they can go
That's the Agmat cadre.
Andaman to Delhi to wherever.
Nagar Haveli, etc.
So, but anyway, the point that I'll just finish these points because this is insofar as on the law. The next point is that only. I'll be dealing with this. The simple question is, once you allocate Mr. Singhvi to the NCT, how do you control what Mr. Singhvi, where he's posted, except the government of NCT will control? You have relieved him, but you may not. There are a lot of cases where you can't relieve him. But once he has gone to NCT, where I'll be posted, whom I will report to, who will write my CR, how will I deal with it, 10 times I'll be posted. That has to be, otherwise the implementation of the NCT government will be stopped. Today, all that is happening, the LG says, no, I'll decide all this. Everything. Well, this is a matter of moment because your lordship would have to decide ultimately whether Delhi's running would come to a standstill on every petty issue. Which is happening when your lordship, all of us are disturbed. We see the press everywhere. I may be a penny here or there, doesn't matter. There's a stalemate. Well, there's a saying in Hindi, Ek myan mein do talwar.
Exactly.
Two swords in one scabbard. Well, how can you conceive of a duality of a power structure within the state? And your lordships are more experienced because even we as the officers have had government servants. The moment the government servant knows that the boss to whom he is reporting can do nothing about it, your lordship cannot deal with the clerk with great respect. Your lordship deals with this everyday situations, whether as high court judges or as district judges or as law officers. How does your lordship deal with a man who knows that, look, my master is there or somebody else? I may not report to you, I may report to him first, I may give you half information, I may be delayed, etc. We'll see. It's chaos. But let me finish my conceptual point because when I show the material on these 12 points, your lordship will be very interested in a minute. So I've done, I think, 8 or 9, depending on what is noted. Well, one more point, 9th or 10th.
9th.
Technically, this means, when I read 368 of our constitutional amendment says that if you touch any of the lists, because touching a list, 2 and 3 directly impinge on states. 1, if you enlarge, may impinge on a state. Suppose I add an entry to 1. So for all 3, you need 2/3 in parliament plus 50% of the states must consent. Without insofar as you'll have to amend the list. 7th schedule list 2. With 50% consent of states and 2/3 of parliament. Then the last 2 points are, one is, there is a very important judgment of your lordships in my written submissions, para 20, Prem Kumar. It makes it clear that once you leave 246, under part 14, that case Prem Kumar arose under article 312, not 246. Once you leave 246 in the 7th schedule, then state will include union territory. But because you were in the 7th schedule and 246 governed, so you had to do this. I hope I'm clear. Prem Kumar holds that state will include union territory. It's only for 246 purposes that it will not include. Only for that purpose. And then lastly, which are in para 28, 30 and 31 of my written submissions. I have given paras 28, 30 and 31. These are my written submission paras. I have given many examples of Delhi exercising legislative power, creating bodies requiring civil servants across the board. Take, for example, how does Delhi have a Delhi Minorities Commission? The Minorities Commission can't function with the Minorities Commission chairman getting up and serving tea himself. He has to have a staff. How do I create the Delhi Women's Commission? Delhi Commission for Women, it is called. How do I have Delhi Lokayukta? They're all laws passed by legislature of Delhi with the staff. Now tomorrow, Malas, that staff, its transfer, it's dealing with that. If the LG says, I will do everything, then Malas, I can't have any, the body is there in name, but there is nothing to implement the policy without a staff. I've given that. Now let me go in quick succession rather than that sequence. I think it was by 11, 12 points. Let me just quickly show it. It won't take time now. Only the paras of the judgment have to be there. First turn to 246. 246. It's just after 239 mm. It's part of the Constitution. And your Lordship will see it in the context of 7th schedule. I'm sorry, in between is that long Panchayati Raj and municipalities. So it goes on to 243, A, B, C, D, E, F, etc. So then Lordship will just see from the scheduled, legislative relations, subject matter of laws made by Parliament and by the legislatures of states. Not, may I read it please? Notwithstanding anything in clauses 2 and 3, Parliament has exclusive power to make laws with respect to any of the matters enumerated in list 1 in the 7th schedule referred to as the Union List. Notwithstanding anything in 3, so 1 is notwithstanding both 2 and 3, 2 is notwithstanding 3. Notwithstanding anything in clause 3, Parliament and subject to clause 1, the legislature of any state also shall have power to make laws with respect to any matters enumerated in list 3 in the 7th schedule referred to as the concurrent list. Then descending order, number 3, descending order. Subject to 1 and 2 above, that is what your Lordship has read of. The legislature of any state has exclusive power to make laws for such state or any part thereof with respect to any of the matters enumerated in list 2 in the 7th schedule referred to as state list. Then, Malas, any territory not included is a separate category. That is, Malas, Parliament has power to make laws with respect to any matter for any part of the territory not included in a state. That will be a union territory also, Malas, not included in a state. Notwithstanding that such matter is a matter enumerated in the state list. What my Lord Justice Chandrachud said in the morning. Now, keeping this. Now, as drafted, it is clear that state can't include UT in 246. For purposes of 246, it can't. If 246 says India is state A, state B, state C. Parliament has power in 1, state has power in 2, and both have power in 3. And then apart from state A, state B, state C, there are territories not part of any state. That also Parliament has full power. So clearly, whether the state and the UT are mutually non-intersecting circles. That's the way 246 is drafted on the face of it, on the text alone. You don't need law for that. Now see 7th schedule. Non-intersecting, mutually non-intersecting circles. Schedule 7, see the first line. It is frequently forgotten. That's how 7th schedule. First line. Only the first line above union list. Bracket article 246. Therefore, for 246 and for 7th schedule, state can never be UT or vice versa. This is also clear from Kanyan. I'm just repeating something which is obvious, but I will finish this first before I come to your Lordship's paras. Imagine finishing, you quoted it. Have you quoted it?
What is Kanyan's citation?
The name is Malus bookmark 51. 1968 to SCR 103. My Lordship has got it in my written submissions, cross-referenced in your Lordship notes as para 50. And in that, your Lordship will see only one para. Just see Manus para. Para 4. It's a constitution bench, Manus. And just see para 4. Parliament has plenary, this is only restricted to 246. Manus, if your Lordship is using the soft copy, it's page 4138. 4138.
Convenience volume 1.
Convenience volume 1, number 1. Parliament has plenary power to legislate, may I read, for the union territories with regard to any subject. With regard to UTs, there is no distribution of legislation. 246(4) enacts that Parliament has power to make laws with respect to any matter or any part of the territory of India, not included, notwithstanding such matter as a matter elementary state laws. RK Union, it was pointed out that having regard to 367, the definitions of state in 358, 3(58) of General Clause Act applies to the interpretation of the Constitution, unless there is anything repugnant. Under that definition, the expression state, as respects any period after the commencement of the Constitution, quote, shall mean a state specified in the first schedule and shall include a union territory, unquote. But the inclusive definition is repugnant to the subject and context of Article 246. There the expression states means the state specified in the first schedule. There is a distribution of legislative power between Parliament and the legislatures of the states. Exclusive power to legislate with respect to the matters enumerated in the state list is assigned to the legislations of the states established by Part 6. There is no distribution of legislative power with respect to UTs. That is why Parliament is given power by 246(4) to legislate even with respect to matters enumerated in the state list. If the inclusive definition of state in 3(58) of the General Clause Act were to apply to 246(4), Parliament would have no power to legislate for the UTs with respect to matters enumerated in the state list. And until a legislature empowered to legislate on those matters is created under 239A for the UTs, there would be no legislative competent to legislate on those matters. Moreover, for certain territories such as Andaman and Nicobar, no legislature can be created in 239A, and for such territories there can be no authority competent to legislate with respect to matters enumerated in the state list. Such a construction is repugnant to the subject and context of 246. It follows that in view of 246(4), Parliament has plenary powers to make laws for union territories on all matters. Parliament can by law extend the Income Tax Act to union territory with such modifications as it thinks fit. President of the exercise powers under 240 can make regulations which have the effect and force and effect as an act of Parliament which applies to that territory. The President can therefore by regulation made under 240 extend the Income Tax Act to the territory, etc. Now, this would have required an amendment to every entry which you wanted to apply to NCT under 239AA had this position remained. Now, may I just first go to the two paras of the judgments of my Lord Justice Chandrachud and my Lord Chief Justice Mishra, and then come back to my other. Please turn to my Lord Justice Chandrachud's judgment 461. 461.
Convenience compelled.
That is the 2018 Constitution Bench.
Page number?
4647.
46?
59.
All my dots are there.
Can you repeat?
Yes, I just.
This will be in volume 2.
Convenience. It's volume 1.
It's number 59.
Page 4882.
It will be in number 2. Huh?
Serial number.
It will be convenience volume 2.
Yes. Starts at 647, Dr. Singhvi, 2018 8 SCC 501.
I'm waiting. At 4882. at 4082.
This is in which, volume 2?
Volume 1.
Volume 1 was all these major judgments and compilation, volume 1.
It is compilation comprising only of judgment. We have a 4647.
What is the serial number of the judgment in volume 2?
This bookmark number is 59?
Marking is not there.
59? 59 is the bookmark number. The relevant page for the para concerned is 4882. It's there in your loss.
No, it's, my convenience compilation ends at 48.
Your PDF number,
Huh?
abhi bata do.
The third one.
The first one. The Lordship will number it first if it is not numbered.
Try PDF 4879.
4879. नहीं आया.
4879 PDF number. I think so, if I'm not wrong.
Oh, 4647.
Mark this compilation is convenience 1 for the law.
Your judgment.
This is the first one we filed.
Oh.
Now in this fellas,
1 minute. Chief hasn't got it.
Internal page of the report?
736.
Internal page where your judgment starts will be 1 minute. Will be 650.
Oh, 650. So it will be around 480.
my lords have it.
Correct,
I read.
Brother, आपको मिला? It is at 796.
Oh, there is a problem. May I read minutes from 460? Para number.
Yes,
Mr. Shah has got 460.
I've got from convenience company.
All my lords have it. May I read?
Just
Oh,
1 second.
Yeah, I'm sorry.
Para 460?
460.
What? Para.
Para 460.
At internal page what of the report?
736.
736.
Yes.
50. $463, right?
460.
460.
460 is the para.
Yes, para number. Para number. At page 736.
Yes. 4886.
No, I haven't got it. The one I'm referring to. So
Convenience compilation, bookmark 59 is the constitution bench
Thanks. So you are
in the same
482.
case, NCT, between the same parties on largely the same issues.
2020.
No, you'll get it at page 4886.
if I have the right company.
In volume, it's in
compilation volume 1.
Okay. And what is the period?
it's page 4882. Actually,
Yes.
4886.
Could my lords look at not the index page, but the printed page on top, 4882,
Yes.
has to be the same. It can't change.
And the PDF page is 4886.
Yes, 488.
Got it? Murari bhai, मिल गया आपको?
Yes.
Yes.
Actually, this 4882 big print on top is the correct page, but your lordship is adding 4 pages of the index. So
For
it
the
becomes
PDF.
4886. Therefore, Malas, it's matching. It's matching. May I read, Malas? So, most important is my lord's title at page 4882 is insofar as any such matter. My lord addresses the. Now, may I read? In the state list and the concurrent list of the 7th schedule, there are numerous entries which use the expression state. These entries are illustratively categorized below. So this point is that I don't understand how they can again revisit this. Libraries, museum, etc., controlled by the state. My lord italicizes it. Trade and commerce within the state, subject to the provision of entry 33. Elections to the legislature of the state, subject to the provision of law made by Parliament. Salaries and allowances of members of the legislature of the state, of the speaker and deputy speaker and assembly. There is no legislative council of the chairman himself. All the italicizing is done by a lordship, identifying powers, privileges, and immunities of the assembly and of the members of the committees thereof. And if there is a legislative council, of that council and of the members and the committees thereof, enforcement of attendance of persons for giving evidence or producing documents before committees of the legislature of the state. Salaries and allowances, which my lord mentioned just before lunch or just after lunch. Salaries and allowances of the ministers for the state. Then 41 is your lordship's entry today. 40, State Public Service Commission, state and state. State pensions, that is to say pensions payable by the state or out of the consolidated fund of the state. Public debt of the state. Preventive detention, list 3 months. For reasons connected with the security of a state. Removal from one state to another state of prisoners, accused persons, persons subjected to preventive detention for reasons specified. Recovery in a state of claims in respect of taxes and other public demands, including areas of land revenue. Sums recoverable as such arising outside the state. Now kindly read 461. 239 permits the Legislative Assembly of the NCT to legislate on matters in the state list, except for entries 1, 2, and 18. Entries 64, 65, 65 as far as insofar as they relate. And on the concurrent list, insofar as any such matter is applicable to the union territories, full stop. In forming an understanding of these words of 239 it has to be noticed that since the decision in Kanyan, right through to the 9-judge decision in NDMC, and Kanyan was reaffirmed in NDMC also, it has been held that the expression state in 246 does not include a union territory. But how many times are you to revisit this proposition? Just because it doesn't suit the government of India? My lord has spent time. The expression insofar as any matter is applicable to union territories cannot be construed to mean that the Legislative Assembly would have no power to legislate on any subject in the state or concurrent list merely by use of the expression state in that particular entry. This is the exact contention I am making a respectful submission on. This is not a correct reading of the above words. As we see below, that is not how Parliament has construed them. Section 7.5 of the NCT Act provides that salaries of the Speaker and Deputy Speaker of the Assembly may be fixed by the Assembly by law. 19 provides that members of the Assembly shall receive salaries and allowances as determined by the Legislative Assembly by law. 43.3 similarly provides that salaries and allowances of ministers shall be determined by the Legislative Assembly. However, 24 provides that a bill for the purpose has to be reserved for consideration of the President. Parliament would not have enacted the above provisions unless legislative competence resided in the states on the above subject. Parliament would not have enacted the above provisions until legislative competence resided. A very, very important sentence. The subjects pertaining to the salaries and allowances of members of the legislative state, including Speaker and Deputy Speaker, and the ministers of the state are governed by entry 38 and entry 40. The NCT Act recognizes the legislative competence of the Legislative Assembly of NCT to enact legislation on these subjects. The important words are legislative competence. The use of the expression state in these entries does not divest the jurisdiction of the Assembly, nor are the words of 239 exclusionary or disabled. And let us kindly note, I am asserting the same power for 41. Your lordship is given 10 sections. Well, it is not such a big issue.
Let's see what 463
yes, 463. The purpose of the above narration is to indicate that the expression state is by itself not conclusive of whether a particular provision of the Constitution will apply to UTs. Similarly, it can also be stated that the definition of the expression state in 3(58) of the General Clauses Act will not necessarily govern all references to state in the Constitution. If there is something which is repugnant in the subject or context, the inclusive definition in 358 will not apply. So all the will apply, but 41 will not apply. That is repugnant. This is made clear in the precedent emanating from this court. In certain contexts, it has been held. In certain contexts, it has been held that expression state will not include duties, while in other contexts, the definition of 358 has been applied. Hence, the expression insofar as any such matter is applicable to duties is not one of exclusion, nor can it be considered to be so irrespective of subject or context. Now, Manas, just pause here. You can always, Manas, keep on making nuances and distinctions and referring to 7, 9, 11, as if your Lordship has abundant time to do these, Manas, delightful, Manas, flight.
So the learned Solicitor General would perhaps try and bring it within the last sentence of para 463, that you have to look at the subject or context. That seems to, from what he just said.
I understand that. Now, just keep these 3 paras open. Juxtapose the impune notification. Is that notification in any manner, Manas, consistent with this, in whatever manner your Lordship reads these 3 paras? Notification basically 2 things. One, entry 41, these institutions don't exist in your state, out you go. 2, where there is legislative power in the parliament, all executive power is also in parliament, you have no executive power. That's all it says, it's 2 paras. Can it, with great, then why did your Lordship sit in a constitution bench to decide all this? So the whole thing is negated by this interpretation. And it is directly dealt with, I say.
How is Chief Justice Mishra dealing?
Now come to Justice Mishra, Chief Justice Mishra, 204. Yes, let's start with 39 first.
What is the internal page?
39 is, come on.
You can give us the printed page also at the top, like 4882 or whatever.
4714. That is Manus plus your Lordship's 4 index pages. So 4714 is without the index pages.
47.
You know?
39.
39. Murari bhai.
Yes, sir.
Six, 8.
Okay.
Yeah, read it, Manus.
Yes, please.
The respondents also contend that although 239AA, this is a direct contention in the other case. The respondents are the Government of India. That although 239AA confers on the Legislative Assembly of Delhi the power to legislate with respect to subject matters provided in lists 2 and 3 of the 7th schedule, yet the said power is limited by the very same article when it employs the phrase insofar as any such matter is applicable to UTs, and also by specifically excluding from the power of the Assembly certain entries as delineated in clause 3A.
So that was a submission which was recorded.
Direct verse. This restriction, as per the respondents, limits the power of the Assembly to legislate, and this restriction has to be understood in the context of absolute text. So, either there is explicit exclusion, they argue the other side, or there is implicit exclusion. Both are applied against me. Nowhere is it so found. Now turn to those paragraphs. Come to 204 first.
Page, the running page in your copy.
This is 4769, internal pages 623.
Para 204. Para 204, right?
Yes, 204. Drawing an analogy while interpreting the provisions of 239(3)(a) and 239(4) would reveal that the executive power of the government of NCT is coterminous with the legislative power of the Assembly, which is envisaged in AA3 and which extends over all but three subjects, kindly mark this, which extends over all but three subjects in the state list and all subjects in the concurrent list. And thus 239(4) confers executive power on the Council of Ministers over all those subjects for which Delhi Legislative Assembly has legislative power. This can't stand, Manoj, with the notification. This can't. Now come to Manoj 219, which is 2 pages later. It is the pages 4772. Internal page is 626. Thus, it is evident from clause 3 of 239(a) that Parliament has the power to make laws for NCT on any of the matters enumerated in the state list and the concurrent list. And at the same time, the Assembly of Delhi also has legislative power with respect to matters enumerated in the state and concurrent list, except matters with respect to entries which have been explicitly excluded. Very clear. 1, 2, and 18. Now come to para 222. A conjoint reading of 3A and bracket 4 reveals that the executive power of the NCT is coextensive with the legislative power of the Assembly, which is envisaged in 3 and which extends over all but 3 subjects in the state list and all subjects in the concurrent list. So all is repeated. All but 3. And all subjects, and thus Article 239(4) confers executive power on the Council of Ministers over all those subjects for which Delhi Assembly has legislative power. 230, I'm reading 223 now. 223, perhaps I can skip. May I read that very well? 239(3)(a) reserves Parliament legislative power on all matters in the state list and concurrent list. So again, all. But clause 4 nowhere reserves the executive power of the Union with respect to such matters. This is very important.
Very important.
Nowhere reserves the executive power of the Union. On the contrary, clause 4 explicitly grants to the government of Delhi executive powers in relation to matters for which the Assembly has power to legislate. The legislative power is conferred upon the Assembly to enact, whereas the policy of legislation has to be given effect to by the executive, for which the government of Delhi has to have coextensive executive powers. And this is where civil service comes in. Such a view is in consonance with the observation of Ram Javaya, which has been discussed elaborately. 224 now. Article 239(4) confers executive powers of the government of NCT, whereas the executive power of the Union stems from Article 73 and is coextensive with Parliament's legislative power. Further, the ideas of pragmatic federalism and collaborative federalism will fall to the ground if we are to say that Union has overriding executive power even in respect of matters for which the Delhi Assembly has legislative powers. This, I would say, concludes the matter, unless your Lordship is constantly being asked to refer here and there. Thus, it can be very well said that the executive power of the Union in respect of NCT is confined to the 3 matters in the state list for which the legislative power of the Delhi Assembly has been excluded under 3A. Such an interpretation would thwart any attempt on the part of the Union to seize all control and allow the concepts of pragmatic federalism and federal balance to prevail by giving NCT some degree of required independence in its functioning, subject to the limitations imposed by the Constitution. I would say not pragmatic or cooperative, no federalism at all can exist if you do not have this modicum of power. Then Manus 245.
Actually, para 224 is a clincher, that one sentence.
I beg your pardon?
Para 224
Yes.
according to us clincher. Thus, it can be very well said.
But you're also absolutely right. But leading up to the totality also, leading up to
229 then.
229. The counsel for the respondents has sought to impress upon us, upon this court, that the term any occurring in the proviso to clause 4 should be given widest import. Now, this is not relevant because this is the disagreement on any matter. That also is, he said any will mean every or anything. That also should be given widest import in order to include everything which is ambit, and for the said purpose, reliance has been placed upon Tej Karan. It has been highlighted in the earlier part of the judgment that while interpreting a constitutional provision, construing the meaning of specific words occurring in a constitutional provision, the court must read the same in a context in which the words occur by referring to the annexing words of the said provision, and also bear in mind the concept that we have adverted to. As regards the importance of context while deciphering the true meaning and interpretation, Austin made the following. When I say the word any in a statute, I immediately know it is unlikely to mean anything in the universe. Rather well put ones. Any will have a limitation on it depending on the context. When my wife says there isn't any butter, I understand that she's talking about what is in our refrigerator, not in the whole world. Very well put, I think. We look at the context over and over in life and in law. Whereas 244 will suffice unless I'm happy to read anything else, but 244 now. And then 245 after that. 244 is at Manus page 4780, internal page 634. Upon scanning the anatomy of the 91 Act, we find that the Act contains 56 sections divided into 5 parts, each dealing with different themes. Now we may refer to some of the provisions contained in Part 4, titled Certain Provisions Related to LG and Ministers Relevant to the Case Line. Section 41 deals with matters in which the LG may act in his discretion and reads thus. So, Manus 41 is quoted. This is the discretion one where he has to, he can't be, there's no aid and advice, including several others, quasi-judicial functions. The Lordship sees the second item in 41. Judicial or quasi-judicial functions stated there. There are many more, the Lordship has that. 245. A careful perusal of 41 of the 91 Act shows that the LG can act in his discretion only in matters which fall outside the competence of the Legislative Assembly of Delhi or in respect to matters of which powers are entrusted or delegated to him by the President, or where he is required by law to act in his discretion or to exercise any judicial or quasi-judicial functions. And therefore it is clear that the LG cannot exercise his discretion in each and every matter. And by and large, his discretionary powers, very important, by and large, his discretionary powers are limited to the 3 matters over which the legislative power stands excluded. So, but there is a harmony brought about to the scheme without which one's real functioning would become impossible. I'll just go to the conclusions now on this, fellows. 284 is the para number at the end of Justice Mishra's judgment. 4794. 284. It's a large para, long para.
1 minute. 284 points, which point?
284.14, which is at 4794, internal page 648. Three of these para, 14, 15, and 16. The interpretive dissection of 239.3 reveals that Parliament has the power to make laws for the NCT of Delhi with respect to any matters enumerated in the state list and the concurrent list. At the same time, the Legislative Assembly of Delhi also has the power to make laws over all those subjects which figure in the concurrent list and all but 3 excluded subjects in the state list. All but 3. Then minus 284. A conjoint reading of clauses 3A and 4 divulges that the executive power of the government is coextensive legislative power of the Delhi Assembly, And accordingly, the executive power of the Council of Ministers of Delhi spans over all subjects in the concurrent and all but 3 excluded subjects in the state list. However, if Parliament makes law in respect of certain subjects falling in the state list or the concurrent list, the executive action of conform is obvious. You can't have an acting contrary to a Parliament. That is now 16. As a natural corollary, very, very important. It's about, again, in this aspect of Union, para 284.16. As a natural corollary, the Union of India has exclusive executive power with respect to NCT relating to the 3 matters in the state list, in respect of which the power of the Assembly has been excluded. In respect of other matters, the executive power is to be exercised by the government of NCT. This, however, is subject to the proviso to 4, which is reference to the President of India. Not in every matter, but in important matters.
Definitely.
Such an interpretation would be in consonance with the concept of pragmatic federalism and federal balance by giving the government of NCT some required degree of independence subject to the limitations imposed by the Constitution. Now, to say that para 39 with the exact insofar as is noted is remotely accepted would be a travesty, is my humble submission. To suggest that insofar as, which is the heading of Justice Chandrachud's judgment, accepts any of the elements in the notification included would again be equally a travesty, is my humble and respectful submission. And Manoj, it is not fair, least of all for the government, is doing nothing but a second attempt.
So basically, the 2 judgments indicate that the executive power of the state, the GNCTD, extends to all subjects in the state list and the concurrent list, except the 3 excluded subjects. And likewise, the mirror image is that the executive power of the union extends only to the 3 excluded subjects.
And one more sentence, I'm grateful. That's
and
exactly
64, 65, and
one more sentence. The legislative power of the state also remains in all these lists except the 3. Because we have an assembly. You created, there's no point of creating Delhi without the assembly. It's passing laws everywhere. Why should the law be considering hypothetical cases of some collision, some repugnancy? That's not arising here in this case. You are simply issuing a notification, executive notification, purporting to be under 239 AA, saying civil services, out you go. Now, Malas, just to end, and I'm ending my 12 points, Malas, just see 368 only by way of peripheral, Malas, just reinforcing. Article 360 amendment. Before that, Malas, I'm sorry, before that, in my written submissions, there is a list, Malas, given of all the places where it is state. 28. Para 28. My written submissions, para 28.
NCT is 28. NCT is 28.
May I read 28 first?
You are 28.
My written submission 28.
Page
Not
22.
Page 22.
Page 22. I'm grateful. Justice Murari has got it.
Yes.
Yes.
28 is specific to NCT. In the case of NCT, there are a large number of enactments passed by the Delhi Assembly that contain provisions which deal with the creation of posts and conditions. All these laws are passed under 41. What you are saying is something very strange. You, the government of India, are saying that law creating a state commission is not passed. All these laws are passed only relatable to 41 only. Kindly see. A list of these enactments, there are many more. I have given a sample list of them. 1. All of 41 enactments, the Delhi Fire Services Act was enacted in 2007. But each of these I will be showing some sections, maybe tomorrow, very briefly. 6, 7, 8, 10, 11, 14, 16 and 63. Bookmark is 17. Deal with creation of posts and terms of employment services of various personnel who are contemplated to be appointed under this Act. The enactment has also received presidential assent. These provisions can only relate to entry 41. As such, the observation, the decision of Justice Bhushan in para 208, whereas 208 I'll come to separately, that the Delhi Fire Services Act relates to entry 5 of list 2 is erroneous because the provision is related to creation of posts and terms of service can only be relating to entry 41 minutes. There's no other entry. Even if other provisions can relate to other entries. Take the next one. Delhi Commission for Safai Karamchari. I'm only reading this para for Delhi. Safai Karamcharis Act of 2006, and they're all relatively recent. Section 4, Terms and Conditions of Office of Chairperson. Section 5, Salaries, Allowances of Chairperson. Section 7, Staff of the Commission. Then number 3, Delhi Minorities Commission. Bookmarks are all there. They're all on the record in the first compilation. Bookmark 19, etc. Section 3, Constitution of the Commission. Terms and Conditions, Staff. Finance Commission, very important commission. Composition of commission, qualification for appointment, terms of appointment, disqualification for being a chairman, conditions of service of a chairman and the members. Another very important act was Delhi Lokayukta and Uplokayukta. Appointment, duration of office and other conditions of service, removal and staff of Lokayukta and Uplokayukta. Another very important one. All these 5, 6 are very important acts that are used daily in Delhi the most. Delhi Commission for Women Act. Same thing, Manoj, I've given. And then Delhi Electricity Reform Act. This entire DERC, Manoj, all this, your worship gets these appeals from the Regulatory Commission. It's created staff, experts, consultants, everything has to be under this act. Then, Manoj, para 29, the provisions indicated in the above enactment, many of which have also received presidential assent, leave no doubt that entry 41 is not just available to Delhi Assembly, but many legislations have been passed in exercise of it. It's wrong to think that not exercised. Similar is the position in the UT of Puducherry. Now I'm going to Puducherry just for example, not Delhi. There the same thing is happening, but under the Government of Union Territories Act of 1963. 18.1 of that Government of Union Territories Act says, subject to the provisions of this Act, the Legislative Assembly of Union Territory may make laws for the whole or any part of the Union Territory with respect to any of the matters enumerated in state list or the concurrent list, insofar as any such matter is applicable in relation to UTs. Same. The Puducherry Assembly has passed the following acts that establish and create posts which can only relate to entry 41. Now I'm going to read that because 4 are given here. Home Guards, Groundwater Control, Marine Fishing and Public Health. Each is in a bookmark in your Lordship's file. 30. In fact, it is unimaginable that a UT with legislature will not have available to itself entry 41, as that power is absolutely essential for effective service, exercise of almost each and every other power that is relatable to various other countries. Then the third example is Jammu and Kashmir. It's very recent. The recently enacted J&K, etc., Act of 2019 that has created the UT of Jammu and Kashmir, a Commonwealth entity. This enactment is pending challenge before this court on other grounds. Establishes a legislature for the Union Territory of J&K under the Act, and under entry section 32 empowers it to enact any law in respect of list 2 and list 3 except entries 1 and 2. Same thing, Manoj, except 18 is not there, 1 and 2. Similar structure. This is a bookmark. Same, Manoj, entry section 32 I have quoted. Same insofar as any such matter is applicable in relation. I have highlighted it. Para 32. The provision as to services has been made in part 18 of the Act, and the relevant sections in this respect are. Now, these are sections in part 18 of that Government of UTs Act, right? Sorry, Jammu and Kashmir Act, 2019 Act. Provision relating to other services. Every person who immediately before the appointed day is serving on substantive basis in connection with the affairs of the existing state of J&K shall on and from that day provisionally continue to serve in connection with the affairs of the UT of Jammu and Kashmir and UT of Ladakh by general or special order of the LG. Then 2, as soon as maybe after, this also takes care of my Lord's query, other UTs were mentioned. Insofar as with other UTs, they are all the other UTs. As soon as maybe after the appointed day, the Lieutenant Governor of J&K shall by general or special order determine the successor duty to which every person referred to in subsection 1 shall be finally allotted after consideration of option received by seeking option from the employees and the date with effect of which such allotment shall take effect or be deemed to have effect. Then subclause 3. Every person who is finally allotted under the provision of subsection 2 to a successor duty shall, if he is not already serving therein, be made available for serving in the successor duty from such date as may be agreed upon between the government of the successor duty of J&K or in default of such agreement as may be determined by the central government. So well, all these are services in the union territory of the union territory. Not in Puducherry, not in J&K, not in Delhi is anything different. Well, it's 90 and 91. 90 and 91, then I'll go to para 15 years. Other provisions relating to services. Nothing in this section or in 89 shall be deemed to affect on or after the appointment. The operation of the provisions of Chapter 1 of Part 14 in relation to determination of the conditions of service of persons serving in connection with the affairs of the union or the UT. So one is union or any UT. And Part 14 is mentioned there specifically. Then there is 2A. All services prior to the appointed day rendered by a person, if he is deemed to have been allocated to any UT under 89, shall be deemed to have been rendered in connection with the affairs of that UT. Then there is 91. Provision as to continuance of the office in the same post. Every person who immediately before the appointed day is holding or discharging the duties of any post or office in connection with the affairs of the existing state of J&K or in any area which on that day falls within the successor union territory shall continue to hold the same post or office in that successor UT and shall be deemed to have been duly appointed to that office by the government of the successor union territory. I won't read all of this. This is showing the Public Service Commission provisions. Well, what is the point in all this? Just come to 33. Well, 93 is clear. It provides for provisions as to state public service commissions. Come to para 33. The above provisions in particular are 1. Services, show the parliamentary understanding that there can be services of a union territory. This is the point, this is my conclusion. You are not serving in the air, and you are certainly not serving the central government. You are serving in Ladakh, in J&K, in Puducherry, in Delhi. That such services of a UT are envisaged in Part 14 of the Constitution. And that a UT can have its PSC. That's the last provision in J&K. These three are very important takeaways in my humble respectful submission. It is evident that Parliament has exercised its power, in particular the power to create services and a public service commission for the UT of J&K under entry 41, nowhere else. Thus, provision of this Act authoritatively disproves the argument that entry 41 is not available to UTs. Well, all these UTs are exercising power under what? With deepest respect, under what are they? They are lawless completely. The only power is 41. There's no other power. And 41 is the one plucked out in a constitutionally created legislature of Delhi. Well, I have given examples of J&K, of Puducherry and others who are not even constitutionally created. By a notification, you have plucked out the power from a constitutionally created NCT legislature. They're all exercising 41 only. Every act up till now I've cited is 41, nothing else. Para 35. Thus, all the three UTs with the legislature, NCT of Delhi, Puducherry and Jammu and Kashmir. If I want to add a value judgment, the others are not constitutionally ordained. I am constitutionally ordained. Have available entry 41. The only difference is that while the power for NCT flows from 239 of the Constitution itself, in the case of Puducherry, it flows from Section 18 of the Government of UTs Act, and in the case of J&K, from the 2019 reorganization. It puts the case of NCT on a fortiori or a firmer footing, not lesser. Further, the example of Jammu and Kashmir shows the extent of state services in union territory with legislature is a function of its history and necessity. In the case of J&K, as there was a conversion from a full-fledged state to a UT, the first case of a reverse conversion, state becoming a UT, first case. In the case of J&K, as there was a conversion from a full-fledged state to unity, the administrative architecture with respect to the services was that of a state, and there existed full-fledged state services and state public services commission. Accordingly, the same were continued. In the case of NC, prior to introduction of 239, Delhi was serviced by All India Services and Central Company Services. This is important. Delhi was serviced by All India Services and Central Company Services. The same was continued post introduction of 239 with some additions made in various legislations. Thus, the existence and extent of state services in a union is a function of historical factors and cannot be the basis of determining whether a field of legislative power under 41 is available. Now, this is important, Malas, on the other point, existence and exercise of power. Field is available, it's been exercised many times. I'm now dealing with the larger issue that suppose it had not been exercised. Doesn't matter. Doesn't matter. That power is page 30 top. That power is undoubtedly available to union territory with the legislation. The Balakrishnan Committee, apart from being wrong for other reasons, also conflates the existence of a power with its exercise and the extent of its exercise. It's completely erroneous. In fact, it is settled law that the existence of power and exercise are different things, and whether a power exists cannot be derived from whether and how often it has been exercised. This is without prejudice in the alternative argument.
Justice Bhushan's judgment is entirely based on Balakrishnan's opinion.
Entirely. Balakrishna report omits to even mention Prem Kumar, which I am about to read. The structure of state and union territory in Prem Kumar is ignored. The commission is totally wrong on constitutional law. But just to end this on exercise, this is paragraph 38 is without prejudice in the alternative. Above this, all this, I have shown a lordship the actual exercise of power. Now I am showing it doesn't matter. Is the entry 41 there or not? It is not created for some third party. It is created for NCT only. Once you make a legislature. Now, this proposition 38 is, in fact, it is settled law that the existence of power and exercise are different things, and whether a power exists cannot be derived from whether and how often it will exist. I'm sorry to digress. Apropos Justice Narasimha's query, not only is the Justice Bhushan judgment on Balakrishna's report, Justice Balakrishna's report is expressly rejected as worthy of reliance by the Constitution Bench. Expressly. Saying that when we have the text and we have the context, we don't rely on it. And my Lord is right, it is entirely based subsequent. That's a two-judge bench. But let me first, it follows on two-judge. Justice Bhushan is part of this also. Now come to this. State of Haryana. Bookmark 53. I'll just read from here, just that para is enough. You don't need to go to the judgment. May I read from here, please? Yes. In the two cases discussed above, no provision of the Central Act was under consideration by this court. Moreover, power to acquire for purpose of development and regulation has not been exercised by Act 67. The existence of power of Parliament to legislate on this topic as an incident of exercise of legislative power on another subject is one thing. Its actual exercise is another. Well-established proposition. Well, as Kameshwar Singh, it was further contended that the power to make a law is a power coupled with a duty, because such law was obviously intended for the benefit of the expropriated owners. And where the legislature has authorized such expropriation, it was also bound to exercise the power of making a law, laying down the principles on which such owners could be compensated for their loss. It cannot possibly have been intended that the legislature should be under an obligation to make a law in exercise of that power, for no obligation of that kind can be enforced by the court against the legislative body. The entire notification says because you don't exercise the power, therefore the power is out. Two more paragraphs done with section, para 39. In fact, there are various provisions of the Constitution with respect to the Supreme Court that will rarely or never be. Article 127, 228, 138, 139. 127 has been invoked by the Supreme Court actually more than the High Court. The cognate power in the High Court has hardly ever been ignored, I believe once or twice. The Lordship has had 5-6 cases. Are examples of such, it would be impossible to contend account of non-exercise or rare exercise these powers do not exist. In Bir Singh, which is a matter dealing with reservations, recognizing that the services in NCT were central government services. Of course, it is prior to the these services created prior to the 239AA. In fact, Bir Singh recognizes it was not at all concerned with the constitutional implications of 239A, and the same was expressly clarified by the judgment. Now, Bir Singh is something they are relying upon. That is, a constitution based speaking through Justice Goel. I'm just taking care of it here, by saying simple thing. Because he was conscious that the judgment could be misused, as it is sought to be done now today, he added a para 42. How can you even rely on it today? Just see para 42. I'll deal with it later, tomorrow. We make it clear that we are not entering into any discussion as to the special provision status of Delhi by virtue of the provisions contained in 239AA, as the said issue does not arise for our consideration in the present context. There are observations about a pre-situation, and they fortunately make it, because by then, the situation was pre, but the 239AA had come in. So they make this exclusion. One more thing before your lordship rises, just 1 minute we take. Paragraph 15 of my same written submission. 1.5. It is partly there in Justice Chandrachud's judgment, in Chief Justice Chandrachud's judgment.
The same submissions? You want
Same submissions. Going up,
Going back, page 9.
Page 9. It'll just take a minute.
That Bir Singh is a constitution bench judgment, no? It's about the ST of Delhi.
Reservations, correct, reservations. No, I find that judgment also one of the relatively smaller but still relied upon, so I'm just clarifying. I'm going to just turn the page as your lordship rises. At page 9, this is several other, many are actually covered in Justice Chandrachud's judgment. But this is a list where the word state or states have been highlighted. Your lordship is scroll from page 9 to page 13. I'll just show 368 in passing tomorrow and Prem Kumar, and this point will be over. I'm very deeply aware.
How long roughly will you take?
Couple of hours. Less than couple of hours. Less than couple of hours. Today, we got only 2.5 hours.
Less than couple of?
Less than 2 hours.
Couple of hours means very dangerous.
No. Today, actually it will be.
You can say 1, 2, 3.
Today it will be, tomorrow it will be filling the quota of today. Today we got only about 2.5 hours.
So possibly by about 12 o'clock you'll be
Yes,
done tomorrow?
2 hours I'll try and wind up.
2 hours, okay.
You can come 15 minutes late because we'll have a little mentioning, 10 minutes or 12 minutes of
I'm
mentioning.
obliged. So deeply aware. Deeply aware.
Obliged.